check.
Audio check, 2, 3.
I check.
Audio check, 2, 3.
record. I believe we are right on schedule and ready to proceed to opening statements on the throughput disincentive issue. Anything from council or from the bench before we proceed to those opening statements?
Yes,
Oh.
Your, oh,
I'm sorry, Mr. Hernandez, I'm sorry, go ahead.
sorry. A few things we'd like to bring up. I believe Tuesday afternoon, when Judge DePel was here, we had brought up the commission taking judicial notice of the 2023 IRP filing, which is EO 2024-0020. I just wanted to let the commission know that we're still working with Ms. Van Gerpen to identify the parts of that case that we would like the commission to take judicial notice of. But we'd also like the commission to take judicial notice of certain items in case number EO 2018-0211, and particularly the is that fiscal year? Fiscal year 2023, or program year 2023 evaluation reports filed on June 10th, 2024, and the program year 2023 EM&V audit of the Ameren, Missouri evaluation.
Right, Mr. Hernandez, thank you. I guess I'll ask if council have any objections to that.
At this time, staff would need to review that. We have not had time to review that yet.
Understood.
Same from the OPC, Judge.
Thank you.
And I do have one more matter. And also Tuesday afternoon, we brought up a motion to strike the notice of corrected testimony of Mark Kiesling. I don't know if Judge DePel was able to relay that to you. She had said that she would relay that to you and that there may be an order forthcoming on that issue. So I just wanted to bring it up. We had discussed about the notice of corrected testimony not being necessarily corrected testimony, but a 180 switch, in position of the staff. And if in the alternative, if the commission felt not to strike that testimony, we would like to be allowed to respond to that testimony, since Ameren has the burden of proof in this case, by offering live testimony on the 11-step process during the program issues portion of the case.
Yeah, and I'm vaguely familiar with that, and I mean, I guess I would see what council prefers, and if we're going to take that live testimony, exactly when we're going to fit that in. And if you know now, that'd be fine, but I don't know what council had preferred to get that live testimony in.
Staff has no issue with the live testimony.
I mean, we would prefer that it be stricken from the record, because again, I think the company hasn't, through testimony, written testimony, been allowed to respond to that. But if the commission denies that, I think the appropriate time would be on the last issue, the programs issue, to fit that 11-step process discussion in.
All right, I'm going to deny the motion to strike, and we can take up the live testimony tomorrow when we get to programs. And if you'll let me, I guess, give me some heads up on as to when you'd like to do, if you want to do that at the end of all the witnesses or some other time, so I can update the commissioners so they can be prepared for that.
Okay, we can think on that and let you know, Judge. Thank you.
Very good, thank you. Anything further before opening statements? All right, I believe Ameren, Missouri is first up. Mr. Hernandez, when you're ready.
Good morning. May it please the commission. Again, my name's Jennifer Hernandez, and I'm representing Ameren, Missouri. So the issue we are starting with this morning is the throughput disincentive mechanism issue. And I want to start the discussion by pointing the commission to the MEEIA statute, in particular 393, 1075.3, paragraph 2, and it provides, "It shall be the policy of the state to value demand-side investments equal to traditional investments in supply and delivery infrastructure, and allow recovery of all reasonable and prudent costs of delivering cost-effective demand-side programs. And in support of this policy, the commission shall ensure the utility financial incentives are aligned with helping customers use energy more efficiently and in a manner that sustains or enhances utility customers' incentives to use energy more efficiently. When Ameren, Missouri incentivizes a customer to install an energy-efficient measure and thereby use less electricity as a result, it is inherently encouraging the customer to buy less of the company's primary product. It is recognized in the MEEIA statute that for it to be reasonable to expect electric utilities to encourage such activities and reduce their own sales, and thereby profitability, the utility should be made whole for the negative financial impacts of those self-induced sale reductions. This aligns the utility's incentives with the interest of its customers in reducing their energy usage, and along with the earnings opportunity, turn energy efficiency into a win-win proposition for utilities and their customers. Ameren, Missouri's demand-side investment mechanism has a throughput disincentive mechanism that effectively looks at measured and verified savings and recognizes each of those kilowatt hour as a source of lost revenue and compensates Ameren, Missouri through the rider Energy and Efficiency Investment Charge, or shortened for EEIC, for the portion of that lost revenue that contributes to fixed cost recovery. The throughput mechanism proposed in this application is quite consistent with the methodology used from 2016 forward. But now, all of a sudden, after 8 years, staff is suggesting that such mechanism is illegal, although staff signed onto 4 stipulation and agreements that endorse the use of this mechanism. And that was EO 2018-0211, the stipulation and agreement filed on October 25th, 2018, the stipulation and agreement filed July 10th, 2020, the stipulation and agreement filed October 13th, 2021, and the stipulation and agreement filed August 3rd, 2023. Also, the Commission issued its order in EO 2019-0132, which is the Evergy MEEIA 3, issued December 11th, 2019. If the throughput disincentive was illegal after PISA was enacted in the summer of 2019, then the Commission would not have allowed Evergy a TD and would have repealed that section of the rules. Ameren, Missouri is trying to do the right thing for its customers in this application before you. The company's preferred plan is based on the primary criterion of identifying the plan with the lowest net present value of revenue requirement, i.e. the most affordable plan for its customers. The alternative plan that would meet customers' needs without DSM is expected to cost customers approximately $4.197 billion more than the company's preferred resource plan on a net present value of revenue requirement basis. And it's important to note that the existence of the throughput disincentive arises as a direct function of bill savings being realized by Ameren, Missouri's customers, bill savings that are created by our programs. As a result, the TD throughput disincentive is a net zero cost to customers. Bill savings to customers on one side and recovery of just a portion of those savings on the other side. This means that customers are seeing net savings on their utility bills as a result of MEEIA due to avoided cost and investments, despite still paying a throughput incentive. If there were no programs and no savings, customers would still be paying for these fixed costs. Staff and OPC have painted only half the picture for you, and you need the full picture to make your decision. Staff and OPC have stated their concerns over the last couple of days, largely as a result of Friendly Cross, regarding EM&V and the TRM. Both EM&V and the TRM interact with the throughput disincentive, and issue 6B today recognizes this interaction. So I would encourage you to ask Mr. Wills questions about how the proposed TD was calculated, as well as encourage you to ask Mr. Grazer about EM&V, the TRM, and how they interact with the throughput disincentive. Thank you, if you have any questions.
Mr. Hernandez, thank you. Any bench questions? Hearing no bench questions. Mr. Hernandez, thank you.
Thank you.
Staff, Ms. Johnson, when you're ready. Chair Hahn, you had a question, I'm sorry.
Yes, sorry. For Ameren Council, can you repeat the end of your opening again? Ask Mr. Wells what?
Yes, Chair, I ask you to, encourage you to ask him questions about how the proposed TD was calculated. And Mr. Grazer about EM&V, the TRM, and how they interact with the TD. Thank you.
Thank you.
All right, Ms. Johnson, when you're ready.
Thank you, Judge. Good morning, Chair Hahn, Judge Pridgeon, Commissioners. May it please the Commission. For the record and for those who are dialed in, this is Tracy Johnson from Staff Counsel's Office. We're on issue number 6, as Ms. Hernandez said, so second to last, throughput disincentive mechanism. Staff has proposed a new throughput disincentive mechanism. It's easier to use. It's based in the reality of actual net variable revenue, which is why Ms. Lange named it the Net Variable Revenue Mechanism. It's supported by the Office of Public Counsel. Now, before we go further, we need to address staff's initial position on this issue. Since Ameren opted in to plant in-service accounting during the Cycle 3 extensions, both the current mechanism and Ms. Lange's suggested mechanism would be disallowed under PISA language. The company's adoption of PISA makes the NTD unlawful regardless of how it's calculated. And the optimal time frame isn't when PISA was enacted, it's whenever Ameren opted in, which was during the Cycle 3 extensions. If the Commission disagrees with this interpretation of PISA, the net variable revenue mechanism created by staff and supported by OPC is the way to go. Ms. Lange and staff designed this mechanism to address the vast number of customers on time-based rates, to account for the Inflation Reduction Act, and to take full advantage of the near-complete AMI deployment by Ameren. To allow the current throughput disincentive mechanism to limp along would require dozens of margin rate calculations, hundreds of technical resource manual load shape calculations, major assumptions about the level of avoided energy sales that may occur, and continued reliance on EM&V, where the EM&V is not even designed to find the answers needed for the throughput disincentive calculations. But now we can rely on reported monthly billing from AMI meters, which reduces errors and the need for future revision. The new mechanism actually reduces risk for Ameren, because any over or under use of energy caused by outside, rogue, or unpredicted events will not create a different outcome than anticipated, because we won't need to anticipate or assume anything. The company will receive the actual net variable revenue. Here's how easy it is. The EEIC tariff sets out rate case net variable revenue for residential and small general service classes by month. Ameren would prepare a report of its actual billings and calculate the actual net variable revenue for that month for each of those two classes. Then, at the time of the EEIC rate change, Ameren would provide work papers showing the difference between the rate case net variable revenue and the actual net variable revenue for all completed billing months available. The difference between the two goes into the new EEIC rate. If the goal is for the company to be made whole, as Ms. Hernandez referenced in her opening, then using the real-time actual values on a monthly basis, as allowed by AMIs, will make them whole. But that's not what the company's arguing for. They want what they've been getting, which is more. The company wants the complex throughput disincentive mechanism they've had since 2016. They want that because it allows for an inflated recovery, even further inflated by the inflated technical resource manual the current mechanism relies on for hundreds of calculations. Dr. Hari Padel is taking the stand to testify on the importance of a reliable technical resource manual and EM&V. The current net throughput disincentive uses monthly savings from the TRM, which is unreliable. Ameren's own witness, Mr. Wills, states in his rebuttal testimony on page 44, starting at line 5, that the mechanism has been consistent for Ameren since 2016. Ms. Hernandez mentioned that in her opening as well. And on page 47 of the same testimony, starting at line 8, he very carefully does not say that the new mechanism doesn't make Ameren whole. He just says that it's less than what they've been getting, a decreased financial incentive. This is one instance, and maybe the only one in this case, where all these details are not needed. There is a simpler way, one without assumptions, and one that allows us to realize some of the AMI benefits. Please ask Ms. Lange about the mechanism. Ask her why her previous support of the current mechanism expired with Ameren's adoption of PISA. Ask her what she has learned and how the process of evaluating MEEIA applications has evolved to better meet the intent of throughput disincentive. Thank you. I'll take any questions.
Ms. Johnson, thank you. Any bench questions? Right, hearing none, thank you very much. Opening from Renew Missouri.
Thank you, Judge. I have no opening on this issue.
Right, thank you. Any opening from NRDC? Hearing none. Any opening, I'm sorry?
No opening from NRDC on this.
Thank you. Thank you very much. Opening from the Office of the Public Counsel.
Just a brief statement, Judge, so if it's okay, I'll just do it from here. Again, the OPC is asking the commission to reject Ameren's amended application in its entirety. We have not taken a position on the PISA issue, but if the commission allows Ameren to implement MEEIA programs with a throughput disincentive mechanism, then we would support staff's suggested net variable revenue mechanism, as Ms. Johnson mentioned. Thank you.
Ms. Van Gerpen, thank you. Any bench questions for Public Counsel? All right, hearing none, I think we're ready to go on to the first witness. I believe it's Mr. Wills. Is that correct?
Correct.
And Mr. Wills, you are still under oath. Anything from Ameren, Missouri before Mr. Wills stands cross-examination?
Nothing further, and we tender him for cross.
Mr. Hernandez, thank you. Cross-examination from Renew, Missouri.
None, thank you, Judge.
Thank you. Any cross from NRDC?
None, thank you.
Thank you. Staff?
Nothing for staff.
Public Counsel?
Nothing from OPC.
Thank you. Any bench questions? Chair Hahn.
Good morning, Mr. Wills.
Good morning.
I plan to follow directions this morning and do as your counsel instructed. So with that, I am going to ask you, talk to me about how the proposed throughput disincentive was calculated.
Sure. I think this is a really important question, right? Is because, as Ms. Hernandez said in our opening, the law's directive is to align the utilities incentives with helping customers use energy more efficiently. And so the way we calculate the throughput disincentive is to exactly do that, right? We look at what were the impacts of these programs on our financial results and make ourselves, make the company whole for those impacts. Now, apparently I was careful to not say in testimony one thing, but I'll say it very clearly right now. Staff's mechanism does not make the company whole. I was not careful to not say it. I just hadn't heard that raised. I'll say it now. The staff's mechanism doesn't make the company whole, because what it doesn't do is restore the financial impact of all of the savings that we've induced through this mechanism. So how we do that is pretty simple. I mean, staff will say it's detailed, and it is detailed because there's a lot of data. On a lot of other topics, staff is asking you to dig into the detail of a lot of data. It can be done, and we do it, and we do it accurately. So what we do is the evaluation, measurement, and verification process is important because it establishes how much savings that our programs created, and it does consider the net to gross factor so that we don't get credit for things that are not attributed to the actions of our programs, right? We take, the net to gross is applied so that those savings that might have naturally occurred are moved out, and we don't recover any throughput disincentive on that. But the things that our programs is credited, that we took actions to reduce our sales, and were successful in doing so, we have those kilowatt hours. There's then a calculation of the rates that those, you look at if a residential customer had kilowatt hour savings, what rate would they have paid us? How much of that rate contributes to our fixed cost recovery? Because if we have variable cost reductions, we don't want to double recover those, right? Because if those cost reductions go away, those get excluded. And we just look at, you saved 1 kilowatt hour, you would have paid us, 8 cents towards fixed costs for that kilowatt hour. We need to recover 8 cents. And the really important thing to think about here is, because you've heard people talk about the overall cost of our MEEIA programs and calling it $600 million or something like that. First of all, I don't agree with that number. But second of all, every dollar of throughput disincentive starts as bill savings for our customers. So our customers' bills are going down before we then recover the fixed cost portion of that. If we don't do MEEIA, the cost of that throughput disincentive isn't avoided by our customers. They still pay the fixed cost through base rates. So if you're looking at the incremental impact of our plan on customers, the throughput, now it's very true that the throughput disincentive causes maybe one customer versus another customer to bear a different portion of the fixed costs, but that's absolutely inherent in rate making. That's going to happen, if there's programs through the IRA and one customer puts in an efficient air conditioner and they reduce their bill, when you get to the next rate case, other customers' bills are going to go up to cover those fixed cost portions. So yeah, there are different, there are different impacts on different customers, but on net for our customer base, there's $0 of incremental cost because of the throughput disincentive. They would pay those fixed costs under our base rates, or with the higher usage where they didn't have the savings associated with our program, or they would pay those costs through the throughput disincentive. Again, people will say that there's no throughput disincentive with naturally occurring energy efficiency or with IRA programs or all these other things. The phenomenon of that exists. Now, granted, we don't recover the regulatory lag on it, and I think that's fair that we don't recover the regulatory lag on those other programs, but the costs are shifted from participants to non-participants in the next rate case
exactly the same, whether it's our program or whether it's the IRA. Those cost shifts are an inherent part of rate making. I'd bet a lot of money that nobody's going to come in and complain that the IRA, shifted costs between customers in a rate case. It's just the same phenomenon. Those customers that actually create savings get more of the benefit because they took action and they managed their bill, they managed their usage, and they produced the benefits of MEEIA. But the overall customer base pays exactly the same. It's just recovering dollars that otherwise would have been recovered without the programs under base rates. I'll stop there for now. But if you have more questions about the details of it, I would welcome.
You hit on something that it is really has been on my mind. I know it's been on the other commissioners' mind too throughout the hearing, and maybe we're just at the point where we just put it on the table, which is the overall cost of the program and the amount of benefits that it delivers to customers. And the chart that keeps coming up in my mind and in discussion with my colleagues, one-on-one, is Jeff Mark's table of $521 million of cost, $200 million of benefits to customers, and basically the comment earlier in the hearing of the math isn't mathing. And, I'm trying to reconcile the program cost with the amount of benefits to customers, and I'm having a really hard time doing that. And I'm trying to figure out, all of these effects. And throughput disincentive is one of them.
Right.
So,
So, yeah, and I don't have Dr. Mark's testimony and that chart in front of me, and I don't, have it committed to memory exactly what's in there and out of there, but I'm pretty sure, as you indicated, that it's referencing the throughput disincentive. I would tell you, as I just did, that the throughput disincentive is not a new cost of the program. It is existing costs that customers pay. So I think that, just out of hand ought to be excluded from that table.
Tell me tell me from your perspective, staff's contention that PISA affected, tell me from your perspective why PISA did or did not impact the throughput disincentive.
Sure, and it's a legal issue, so ultimately, and I'm not a lawyer, I have a
Okay.
little perspective on it, but our lawyers will ultimately argue that, but what
Well,
I
I'm
would
not
tell
going
you.
to ask you for a legal
Yeah, yeah.
conclusion, but if you can tell me just
Yeah,
high
yeah.
level from your
I just wanted to caveat it.
Okay.
The caveat. I'm happy to talk with you about it. I just wanted to caveat that I'm
Yeah.
not a lawyer, and the lawyers will weigh in, right? But so the MEEIA statute existed, predated PISA, right? And it has a directive to the commission to use techniques to align the incentives of customers to, of utilities to encourage efficiency with their customers, right? That is a statutory provision that you've relied on for all of the history of MEEIA to calculate the throughput disincentive and provide recovery of that. The PISA statute passed in 2018 provides an option for how to deal with certain changes in revenues that a utility may elect. The utility is not allowed to elect that option if they elect PISA, but it does nothing to change the authority under the original MEEIA statute for you to provide a mechanism to align our incentives. It didn't, rejecting the option to decouple, that essentially decouple, that's provided in the MEEIA statute, doesn't change the obligation under the MEEIA statute to provide mechanisms to align our incentives. And there's nothing express or implicit in there that does take away the authority out of the MEEIA statute.
Going to be high level at the moment, but MEEIA was passed at a different point in time, than we are currently, where utility, and I'm going off of, this is not necessarily related to throughput disincentive, but just questions that have been percolating. MEEIA was contemplated maybe when there was flat to no load growth, where Ameren had capacity, excess capacity. That doesn't seem to be the picture now. And so I'm trying to contemplate what basically is MEEIA as we've always done it, to a completely different picture. Help me with that.
Yeah, what I think I would do is I would, and respectfully challenge the characterization of what was going on at the time that MEEIA was passed. If you go back, it was passed, I think, maybe around 2009. Our currently effective IRP in 2008 included construction of a second Callaway unit for billions of dollars. Our IRP base load forecast without MEEIA was, I think, about 1.3% annual growth at the time. So there was the beginnings of some efficiency and changes to the load growth environment, but it really, the energy efficiency movements that, other states and Missouri undertook under MEEIA helped usher that in, really, that flatter load growth. I would analogize it pretty similar, that when we were back then looking at building Callaway 2 for billions of dollars, and MEEIA was looked at as a tool to maybe be able to avoid that, maybe be able to manage our capacity position and not have to do as much new build, exactly in the same way as it can be looked at as a tool today. So, I think if you think about the risks facing us from a capacity position perspective, the risks are pretty one-sided. Mr. Michaels mentioned this, I think, a couple days ago. The risks are these, large data centers coming in with large load growth makes our capacity position shorter. environmental regulations that might impact baseload generation, that would cause a retirement, make our generation position shorter. I think it's as important as ever, or more important than ever, to use those tools that we do have in our toolkit to manage load where we can, just to offset, we've got a preferred resource plan that already does include MEEIA as a resource to serve load and new supply side, because both are needed. But if those risks manifest, not having done MEEIA will just exacerbate the risk on needing even more new generation, right? It does manage our load and improve our capacity position, and I think very much in an analogous way to at the time that the MEEIA statute was passed.
There are a lot of assumptions made there, but for now, I'm just going to marinate on it. Thank you, Mr.
Yeah, and I
Wells.
would, I appreciate that, but,
Yeah.
to do planning and have reliability in the future, we can't do that without assumptions. And we evaluate a wide range of potential future assumptions, high and lows of different things, and I think you've got to wrestle with having assumptions in order to have a plan.
I agree. I agree. You have to wrestle with having assumptions. The part that I'm having a really hard time with is the assumptions that have, the world is largely unknown in 15 years. And so saying that there's a $4 billion cost coming down the pike of this, the energy efficiency side of this program is rejected, I really have a hard time with. Because some of the assumptions that have made in the past, generally, some of them have, and a lot of them haven't materialized.
So the number in the future will be different, right? But it won't be, we project 4 billion. You're right, that's a forecast based on assumptions. 4 billion is not exactly what will play out, and you're right, things will change. But the question is MEEIA an insurance policy against some of the more significant risks that could cause the high end of those cost ranges? And I think it is an important insurance policy to prevent some of the more extreme costs where you've got even more build that has to happen. So, I would say, of course the $4 billion is an assumption-based kind of forecast or expectation. The risks to me scare me on the upside if we don't do this.
When we say it's an insurance policy, in my view, it is an insurance policy, but at a cost. And the cost to me is extreme when compared to the cost of new generation, which can be depreciated over the life of the plant, which is far longer than a MEEIA cycle. So I'm trying to balance, I like clearly I like the idea of energy efficiency. The demand response programs work, but in my mind, I'm having a hard time with the cost of the energy efficiency programs.
And I appreciate that, but I do think that's, I don't want to, kind of talk past, but I think that's why even you have to just make some assumptions and look at the comparison of the costs, right? How much supply side we do might change, but we've got a reference point of, is supply side or demand side cheaper? That $4 billion is a good representation of a comparison point between the two. Now, we might need more generation. I kind of doubt it, but we could need less generation. But the inherent cost comparison occurs in that IRP, and we have lots of different worldviews and scenarios where we stress test those and find that it's cost effective.
Thank you, Mr. Wells.
Thanks.
Chair Hahn, thank you. Any further bench questions?
Yes, this is Commissioner Mitchell speaking. And I'm curious from your perspective and your point of view, the notion of the net variable revenue mechanism. Well, what are your specific concerns about that approach?
Sure, yeah, thank you. Thanks for the question, Commissioner Mitchell. I'll try to make it as simple as I can. And I'll use just hypothetical for illustration. So if the company were going to experience, say, 0.5% of load growth next year, if we don't do MEEIA programs, and we would be expecting to experience 0.5% of growth next year, our revenues that we would incur at that time would be based off of the actual sales that include that 0.5% of growth. Now, say the net variable revenue mechanism is put into place and we do MEEIA and we wipe out that 0.5% growth and have zero growth in our revenues. we would have been paid for 0.5% of growth under base rates under traditional rate making. And the net variable revenue mechanism would look back to the last rate case and say, oh, your revenues matched what your revenue requirement was a year ago or 2 years ago, or whatever the kind of historical test year view of your revenues needed to be. So you're good. You don't need recovery of that 0.5% that you could have had if you didn't do MEEIA. And now what I'll tell you is it's important, and Commissioner Mitchell, I know you're relatively new to the commission. I don't know how much you've gotten into rate making in the state, but the fact that we're a historical rate making test year state is very important to that, right? Because it might sound really intuitively appealing to say that, oh, if your rate case said you needed this much revenue and you get restored to that much revenue, you ought to be okay with that. But the fact of the matter is, after that rate case concludes, if our costs increase, we don't get to true those up and recover, costs that have increased since that historical period. But one of the things that offsets that harm to us, that regulatory lag that we experience, is that we also get to keep the benefit of the load growth. So it's really kind of a matching between costs and revenues, that if you're going to reconcile our revenues to match what they were based off of, our revenue requirement analysis from 1 year ago or 2 years ago, but the cost side of our equation is going to be based on our costs today that have experienced inflation and new investment, then we've got a real disincentive to letting go of the kind of the benefit of that growth. And I tried to make that simple, and I probably got a little bit complex. So if you have any follow-ups, I'm happy to take those. But
well, that's quite all right. It helps me understand your concerns.
Right, thank you.
Thank you.
Right, thank you. I think I have just a few questions. Mr.
Judge.
Wills, I'm sorry, any further bench questions?
This is Commissioner Coleman.
When you're ready, I'm sorry.
No problem. Thank you. So, Mr. Wills, this question is kind of leaning towards something I inquired of Dr. Mark yesterday. So this is to give me better clarification from your vantage point. So using your example of one customer installing an air conditioner and another customer paying more as a result, how does this benefit all customers, even those who aren't participating?
yeah, that's a great question, Commissioner Coleman, and I think that's why it's important to look at the total resource cost test, which is both statutorily the preferred total resource, the preferred cost effectiveness test, but it's also the most comprehensive. So if you think about the different ways to evaluate the cost effectiveness of energy efficiency programs, there's several, and Dr. Mark got into this a little bit, there's several different tests that look at several different perspectives. But what you would label, how you would label these essentially is that the participant cost test looks at a participant's perspective. The RIM test looks at a non-participant perspective, and the total resource cost test looks at an all customers perspective. So it is telling what is the impact on all customers. But the other thing that I think is important, when you want to look at what is the impact on all customers, you look at the TRC. Those benefits are real in there. The avoided energy and the avoided capacity benefits reduce our revenue requirement over time, and they cause our rate increases to be to be based off of a lower revenue requirement than they otherwise would be. So the total expenditures of all of those customers are going to be less than they would without these programs. I thought I had one more point, but I lost it. So.
Your answer then, are you saying that Ameren is selling less electricity as a result of the MEEIA programs?
Oh, yes, absolutely.
Okay, just one clarification.
Oh, and I did, the other point I was going to make is probably an even more important view than the TRC view is the IRP. I mean, the IRP is really where the rubber meets the road in integrating this analysis in the most robust and detailed way. And the IRP doesn't produce TRCs and RIMs, it's per se, but what it does, it says, what will our customers' bills be most affordable under? And it says they'll be most affordable if we include energy efficiency as a part of our portfolio to serve customers.
Thank you. Thank you, Judge.
Commissioner, thank you. Any further bench questions? I think I will have a few. Mr. Wills, do you have your rebuttal testimony handy?
I do. Just let me find it.
Sure. And when you
Got it.
get to page 51, could you let me know, please?
Absolutely. Okay, I'm there.
I believe on that page, you state that only 4,660 customers out of over 1 million Ameren, Missouri customers are taking service at the advanced TOU rates. And I believe you also state that Ameren, Missouri included those several 100,000 customers taking service at the evening morning savers rate and its net margin rate calculation, and that's with little or any impact on the throughput disincentive mechanism. Is that correct?
I think you characterized that
Okay.
section correctly.
Are those customers all residential customers?
Yes, this is all discussing the residential, class that has the the relatively new time of use rate options available.
All right, thank you. During Ameren's pending rate case before the commission, if TOU rates were approved for general residential customer use with greater TOU differentials, would the throughput disincentive mechanism be able to be adjusted to compensate for that TOU rate changes, since those rates would be effective during MEEIA cycle 4?
So when you say approved, I mean, so are you saying different time of use rates are approved?
Yes.
I mean, because we have time of use rates. So I think, yes, you can do the calculations for the throughput disincentive with any rate structure. You just have to, apply the right number. So in fact, I think one of the important things is, I'm advocating for not making wholesale changes to the throughput disincentive mechanism. But if it were a concern, staff has said you'd have to calculate a bunch of end-use specific margin rates. That's already done in my testimony and in work papers supporting my testimony for our existing rates. And we could do that if there was a new or different time of use rate. So it's not an intractable problem to do that because I've already done it.
I believe those are all the questions I have. Thank you, Mr. Wills. Any further bench questions? Hearing none, any recross based on bench questions from Renew Missouri?
No, thank you.
Questions from NRDC?
None, thank you.
Thank you. Any cross from staff?
Yes, please, Judge.
When you're ready.
Hello, Mr. Wills.
Hello.
I just have a few things I'd like to walk through to get some clarity here.
Sure.
How many measures are subject to EM&V each program year?
I don't have a specific number that maybe Mr. Grazer might know that, or I don't know if that's a detail he'd have off the top of his head.
Do you think you could quantify it by saying less than half?
Less than half of what?
The members are subject to EM&V each program year. The measures. How many of the measures are subject to EM&V? Could you quantify it as less than half?
I thought you were asking how many measures we have. I think all of our measures are subject to EM&V, so, but I don't think, I thought you were asking me how many measures there are, because, all measures are subject to EM&V.
Okay, we'll clarify with Mr. Grazer, thank you. How do you keep track of which rate plan a customer who installed a specific measure is on today? And how do you keep track of that if they installed a measure last year?
So, are you asking if, I'm sorry, could you repeat your question?
Yeah, sure. I'm just wondering how you keep track of which rate plan a customer is on, specifically if that customer has installed one of the measures in a program And I'm wondering if you keep track of that over time. So if a customer changes between programs, are you tracking the rate plan that they're on if they change between programs, or rate plans if they install measures, if they don't?
I'm not understanding what the purpose of that tracking is for that you're asking for, but I don't think that we have an ongoing tracking of which measure is associated with which rate plan. You know, I think what you're getting at maybe is, you know, our proposal to incorporate time of use rates if the commission wanted to, and the throughput disincentive mechanism relies on an assumption that customers across the various different rate plans participate in measures proportionate to the number of customers on those rate plans.
Thank you for the clarification.
Sure.
This is kind of specific, so hopefully I'll get it right.
Okay.
What is the rate that a customer on a highly differentiated residential rate plan pays for a kilowatt hour used at 5 p.m. on a summer weekday afternoon?
Depends on which rate plan, but they could be around 30 cents a kilowatt hour.
Okay. And the same question, but for a customer on the Anytime Savers program.
I want to say it's 13, 14 cents, something like that.
Subject to check, could you agree that it's about 10?
That the anytime user rate plan summer kilowatt hour is 10 cents? No, I wouldn't agree with that.
Okay.
I mean, subject to check, I would tell you that it's not right.
Okay. So 30 cents, 5 p.m. summertime weekday afternoon. You said 13 to 14 or 14 to 15?
13 to 14. I think it's in between the two.
Okay. Does Ameren still have the opinion that it cannot refund money to customers if EM&V later shows that net throughput disincentive over-recovered throughput due to, quote, normalization violation tax issue? This is in reference to the clawback of...
That's an accounting issue. I don't think the accounting guidance around that has changed, to my knowledge. I'm not an accountant
Sure.
by trade, but my understanding is that accounting guidance still exists.
Okay, so if it hasn't changed, that means that it is still Ameren's opinion that over-recovered net throughput disincentive cannot be recovered because of a normalization violation tax issue.
Objection calls for legal conclusion.
I'm just clarifying what the original guidance was.
Yeah, I'll overrule. He can answer if he knows, and if not, he can say so.
I don't know for certain.
Thank you. What net to gross does Ameren propose for use in its net throughput disincentive for each measure?
I would direct you to talk more with Mr. Grazer about that.
Okay. Okay, I've got a couple questions to clarify some conversations that you had with commissioners. So Commissioner Mitchell, you had a conversation with him, and you made a statement that if your costs increase, you don't get to be made whole for those increases. But you do get PISA treatment for many of those investments, right?
Sure, there are some categories of costs where we get that, but I think
Okay,
it's...
thank you. You also had a conversation with Commissioner Coleman, and you talked about the IRP. So the IRP assumes a 6.1% more energy savings than your MEEIA application, right?
I think it's the number's in the record. I don't remember if it's 6.1, but I'm sure that there's probably some number in the record on it.
And it's more than your MEEIA application.
I'm not 100% sure of that. The number's in the record.
Okay. And the IRP assumed a 4% lower cost than your MEEIA application does, right?
Same answer.
Thank you. Nothing further.
Ms. Johnson, thank you. Any cross from OPC?
One moment, Judge.
Thanks.
No, thank you, Judge.
Ms. Van Gerben, thank you. Redirect?
Yes, thank you. Earlier, there was a staff council question about some categories of costs get PISA treatment, and you were about to say something and you were cut off. Can you continue what you wanted to say on that issue?
Yeah, absolutely. I think the PISA statute speaks to this explicitly in that PISA treatment is not available to for investments in serving new customer loads. And the inherent logic that's got to be behind that provision in the PISA law is that when you make an investment to serve a new customer load, you have costs increasing and you have revenues increasing. And so the PISA statute relied on the utility using load growth to cover the lag from growth projects. So if you rely on PISA to say that, oh, you're getting enough of your costs through PISA of the increasing costs, you're actually gutting the provision of PISA that allows you to retain load growth in order to offset some of the other increasing costs, that being the investment in serving new customers. And beyond that, PISA only covers 85% of those increases. We still have regulatory lag on 15% of our investments that can be help offset by load growth revenues. O&M, most categories of O&M are completely untracked and untrued up, and those can experience cost increases that can be offset. So there's plenty of categories of cost, and there's also specific, I think, clear specificity in the PISA statute itself that presumes that a utility won't be decoupled when PISA applies to it.
Nothing further, thank you.
Mr. Hernandez, thank you. Mr. Wills, thank you very much.
Thank
We
you.
step down. I believe Mr. Lozano is the next witness. Is that correct?
That is correct, Your
I see
Honor.
him approaching the witness stand. And Mr. Lozano, you're still under oath. Anything from Ameren, Missouri Council before he stands cross?
No, Your Honor, other than to tender him for cross-examination.
Ms. Moore, thank you. Any cross from Renew Missouri?
No, thank you.
Thank you. Cross from NRDC?
None, thank you.
Thank you. Any from staff?
No, thank you.
Public counsel?
No, thank you.
Thank you. Any bench questions? Right, hearing no bench questions. All right, Mr. Lozano, thank you very much. Is Mr. Grazer the next witness? I hope I'm pronouncing that name correctly.
Yes, and yes, you are, Your
All
Honor.
right, thank you. And Mr. Grazer, you're still under oath. Anything from Ameren, Missouri before he stands cross?
Nope, just to tender him for cross. Thank you, Your Honor.
Thank you. Any cross from Renew Missouri?
No, thank you.
Thank you. NRDC?
None, thank you.
Thank you. Staff?
Nothing from us, thank you.
Thank you. Public counsel?
Nothing. Thank you, Judge.
Thank you. Any bench questions? All right, hearing none. Mr. Grazer, thank you very much.
Your Honor, at this time, I would like to move for Ameren Exhibit 110 and 111. It was previously identified yesterday. Exhibit 110 is the rebuttal testimony of J. Neil Grazer, and 111 is the surrebuttal testimony of Mr. Grazer.
All right, exhibits 110 and 111 have been offered. Any objections? Hearing none, exhibits 110 and 111 are admitted into evidence.
And Your Honor, to clarify for the record, 111 has both public and confidential versions.
Thank you. And I'll note that as 111 and 111. I'm sorry, is that highly confidential?
No, Your Honor, just confidential.
111 and 111C then. Thank you. All right, I believe we are on to Dr. Pudell, is that correct?
Dr. Goodell just stepped out.
Thank you. Dr. Padel, good morning. You're still under oath. Anything from staff before he stands cross?
We consider him tendered for cross.
Ms. Johnson, thank you. Cross-examination from public counsel.
No, thank you, Judge.
Renew Missouri.
No, thank you, Judge.
NRDC,
None, thank you.
thank you. Ameren, Missouri,
No questions, Judge, thank you.
thank you. Any bench questions? All right, hearing none, thank you very much.
At this time, Your Honor, we'd like to move that his testimony be admitted. It's his last time taking the stand. So Dr. Padel's testimony is found in Exhibit 216, 217, and 218. And at this time, we'd move to admit those.
And to clarify, that would be Dr. Padel's direct is 216, rebuttal is 217, surrebuttal is 218?
Correct.
Thank you. Any objections? Right, hearing none, exhibits 216, 217, and 218 are admitted into evidence. Dr. Padel, thank you.
Thank you.
Next staff witness, I would believe, Jay Lubert. And Mr. Lubert, you're still under oath, sir. Anything from staff before this witness stands cross?
No, staff considers him tendered. Thank you.
Ms. Johnson, thank you. Any questions, public counsel?
No, thank you.
Any cross from Renew Missouri?
No, thank you.
Cross from NRDC?
No, thank you.
Ameren, Missouri?
None, thank you.
Any bench questions? All right, hearing none. Mr. Lubert, thank you very much.
Thank you.
Next witness, I believe, is Ms. Lange. And at the pace at which we're going, I realize we might slow down at any time, but I mean, I'm hopeful that parties are ready to go on to the next issue later today. That we have witnesses available to keep going. It looks like I'm seeing some nods. Okay, very good.
Your Honor, with the caveat that I think we might need a break to contact Mr. Huber to make sure that he gets on the WebEx.
Absolutely, absolutely. Not a problem.
Judge, we would also ask for a brief break just to give us some time to kind of wrap our head around moving to that next issue. So
Sure.
maybe just like after lunch, if that would be an option.
Absolutely, absolutely. Thank you. Anything from staff before Ms. Lange takes cross?
No, Judge, we consider her tendered for cross.
All right, thank you. Any cross-examination, public counsel?
Yes, just briefly, Your Honor. Good morning, Ms. Lange. How are you?
Good morning. Good, thanks.
Good. You were here for Mr. Will's testimony, correct?
I was.
I'm going to attempt to kind of paraphrase what he said.
Your Honor, at this point, I want to renew the objection about friendly direct. I think it's well-established case law that trying to cross-examine a party who is adverse to you, and again, I think OPC, through the staff witness, is trying to flush out more of their position.
Ms. Van Gerben?
Your Honor, I just want to see if Ms. Lange agrees with a statement that Mr. Wills made on the stand, and I'll try to limit it to a closed question.
All right, I'll overrule the objection.
Thank you. So I'm going to attempt to paraphrase what Mr. Wills said. And as I understood it, it was that the throughput disincentive just kind of naturally occurs. Do you agree with that?
I do not agree that the throughput disincentive is naturally recovered in real time. I do agree that over time, those costs that are not recovered from certain ratepayers would be socialized to other ratepayers through the operation of a rate case.
You would agree with me then that increases caused by new load growth would be also socialized in a rate case or lost in a rate case. That would,
I do, and in that answer, I'm realizing a shortfall of what I just said. I need to make a distinction between what would be mathematically solved for as the throughput disincentive and what actually occurs as energy sales avoided. And I don't think that those two are the same. So just like we wouldn't mathematically assume that a load that, you know, if an economic development authority came in and said, we project that we're going to have 10 times more factories operating next year, we wouldn't factor that into rates and we wouldn't consider that, you know, increased revenues. That's also the distinction I would make between the calculations under the throughput disincentive tariff as proposed by the company and any actual throughput reductions that may result due to utility-induced energy efficiency programs.
nothing further. Thank you, Judge.
Ms. Van Gerpen, thank you. Any cross from Renew Missouri?
No, thank you.
Thank you. Cross from NRDC?
None, thank you.
Thank you. Any cross from Ameren, Missouri?
No, thank you, Your Honor.
Thank you. Any bench questions? All right. Hearing none. Ms. Lange, thank you.
Do we have a redirect?
Oh, I'm terribly sorry. Yes, redirect. Thank you.
Thank you, Judge. Just one moment, please. Ms. Lange, I just want to ask you a clarifying question regarding what is mathematically solved for as a throughput disincentive versus what's actually received.
Sure. I'll try to answer this as briefly as possible, and I apologize in advance, it likely won't be. So all of those issues that have been brought up by many parties, rebound, inefficient use of efficiency measures, all of those things, as well as any naturally occurring load growth, as well as any weather impacts or other broader economic impacts that may occur, and those eventually do or do not increase the company's normalized annualized billing determinants in a rate case. So that is, I guess, the actual throughput amount. What the throughput disincentive does, or I should say what I naively thought about 12 years ago the throughput disincentive did, is take a really well-researched, really well-developed idea of how people used energy and look at how that changed when an efficient measure was installed and multiply it by the number of people putting that measure in and give the company the difference between the FAC base, which we were using as a surrogate for the cost of energy, and the retail revenue, and provide the company with that money in real time, knowing we were ignoring weather. It turns out that those aren't well-researched, or at least are no longer well verified, even if they were at the time. It turns out that those are not, the words evaluate, measurement, and verification, it turns out don't really mean what I thought those words meant. So it isn't a case of we're going back and saying, we thought you were going to avoid 10 kWh at a flat rate of 5 cents per kWh. It is a case of we thought you were going to avoid 5 kWh. We gave you credit for, a 75% reduction in that to account for your normalization concerns with the IRS. It turns out that even using verification of whether or not customers did install measures, that you probably only avoided 3 kWh, but we can't refund that 1.5 kWh difference. I'm sorry, my numbers are all over the place. It is an incredibly complex issue that we tried to simplify, and it turns out we made too many simplifying assumptions. Actual throughput is really, really, really hard to figure out. And that's even if everybody's in agreement, everybody's on the same page, everybody, is fundamentally aligned. It's really, really, really hard, if not impossible, to figure out. And that's just very distinct from whether or not the utility actually sold more energy in each year. And generally speaking, Ameren is selling more energy in each year.
Thank you for that. I'd like to move on to a discussion about the throughput disincentive recovery versus or in comparison to a general rate cases. So under the current net throughput disincentive structure,
Your Honor, I'm going to object again. This is more direct supplemental testimony based on and we're getting beyond the scope of her response and the questions.
Ms. Johnson?
Judge, she directly spoke to how it's calculated and when the recovery takes place. She also spoke to actual avoided sales and how those would come about and impact a rate case. So I think this is an explanation and clarification of exactly that.
But I think her response, we have an ask and answer. She already answered the question. She wasn't cut off by counsel, and to elicit further information, I think is improper.
Right, I'm going to overrule.
All right, Ms. Lange, we're on a discussion of throughput disincentive recovery in comparison to a general rate case. Under the current net throughput disincentive structure, are there assumptions that are made to adjust revenues through the course of a rate case?
Yes. So a rate case adjustment is made that ignores factors such as net to gross, that simply says during the test year, X measures were installed in Y month, and Z kWh are associated with that. So we are going to remove the corresponding number of measures from a future month to recreate billing determinants for the entire test period, to create a annualized level that would have existed if every assumption about the impact of those measures was accurate. Now that is applied to, it depends on the timing if it's applied to normalized or unnormalized load, but either way you are aligning assumptions for measures that tend to be related to or tend to be subject to influence of weather to actual load, and you're necessarily always going to have a mismatch there.
And how does that affect rates with all else being equal?
I would be shocked if there's an instance where actual savings were higher than what we annualized in a rate case, which means that we are going to give the company additional determinants which exponentially increases revenue. If you decrease determinants by a factor, you're increasing revenue by a factor, of a multiple of that when you promulgate rates based on those determinants.
So rates go up?
Rates go up, more than they should have, to be clear. Rates, the assumption is rates should go up, but this would increase that.
Thank you. Nothing further, Judge.
Ms. Johnson, thank you. Bench questions, Chair Hahn.
Good morning, Ms. Lange.
Good morning.
In opening statements, and we've talked a little bit about this, I hope I didn't miss it while I was out, but can you talk, I know Mr. Wills talked about this, but talk about why you no longer support the throughput disincentive after PISA? Or post-PISA?
Sure, there's kind of two components to that, if you'll allow.
Sure.
The first is that this staff's position in this case is a return to the legislative discussions, the rulemaking discussions of what this component would look like. So understand that the net throughput disincentive component, when it was developed as a concession to the utility, because they said that, you know, we're gonna take our ball and go home effectively, and that's where we started with MEEIA, is the idea of you don't get recovery for what you didn't sell. I'm sorry, I said that wrong. You don't get recovery for revenues that are still beyond what was assumed in the rate case. That said, with PISA, I mean, it's the actual, sorry, I'm gonna try not to give you 50 citations to my testimony, but it's laid out in my direct testimony, with the problems we have trying to reconcile the language, in PISA and in the MEEIA statute. And essentially staff's position is, due to Ameren electing PISA, any of these mechanisms are not lawful for a utility that has elected PISA. That said, if the NTD is legal, because it's being done under the MEEIA statute rather than the PISA statute, then the staff recommended mechanism is legal for the same reason. And I think that discussion is on, if you look around page 22, is where that discussion would begin in my direct testimony.
Thank you.
Sharon, thank you. Any further bench questions? Hearing none, any recross based on bench questions from public counsel?
No, thank you, Judge.
Renew Missouri?
No, thank you, Judge.
Thank you. NRDC?
None, Judge, thank you.
Thank you. Ameren, Missouri?
Yes, just one quick question. Ms. Lange, do you have, or are you aware, or do you know the date the company elected to take PISA?
It's in my testimony. I don't recall offhand. I think the unofficial motto of staff for years has been, we always reserve the right to get smarter. And frankly, this is an issue I wish we would have caught sooner.
Your Honor, I think the question, the answer was in part responsive to my question, and then I moved to strike the rest because it was non-responsive. I was just simply asking if she was aware of the date, and we've learned that she was, and it's in her testimony.
All right, thank you. That's overruled. Thank you.
No further questions.
All right, thank you, counsel. Redirect?
No redirect, but at this time, we would move to enter Ms. Lange's direct, which is numbered Exhibit 203. My mistake. Direct is 203, rebuttal is 204, and surrebuttal is 205. We'll move to enter those three, please.
All right, Exhibits 203, 204, and 205 have been offered. Any objections? Hearing none, Exhibits 203, 204, and 205 are admitted into evidence.
A point of clarification, Judge, I apologize. Ms. Lange's surrebuttal has both public and confidential.
All right, any objections to, I guess, to clarify 205 or 205C?
None, Your Honor.
All right, hearing no objections, 205 and 205C are admitted into evidence. All right, Ms. Lange, thank you. I believe Dr. Mark is the final witness on this topic. And Dr. Mark, you are under oath. Anything, Ms. Van Gerpen, before he stands cross?
No, Judge, we consider him tendered for cross.
All right, thank you. Any cross from staff?
Nothing from staff.
Thank you. Renew Missouri?
No, thank you, Judge.
Thank you. NRDC?
None, thank you.
Thank you. Ameren, Missouri.
No questions, thank you, Your Honor.
Thank you. Any bench questions? Hearing none? All right.
I've got one.
I'm sorry. Commissioner Mitchell, when you're ready.
Yeah, I don't completely understand the plant in service accounting and how that connects to the net throughput disincentive. And I'm hoping Dr. Mark might be able to explain that to me.
Well, I think the witness before would probably be a better one to explain the timing and the impact that it has on rates. There's two questions, Commissioner, that are in front of you. I mean, one is, I think, more of a legal question. So the PISA statute allows for either plant and service accounting, which, allows for, more contemporaneous recovery of a number of different investments on the distribution, transmission, and to renewable projects presently. If the utility doesn't have to do PISA, if the utility has an option, and one of that options is decoupling. And the decoupling mechanism is something that Liberty Utilities had elected the first time around, and then it's since withdrawn that and has moved for PISA. MEEIA allows for lost revenue recovery from the energy efficiency savings associated, verified energy efficiency savings from these programs. Now, the mechanism that could be utilized for that has gone through many different iterations. So if you look at different states, the standard, or generally the most preferred way to do that is decoupling for energy efficiency. Decoupling is sort of a negative connotation within the context of our world sometimes from a consumer advocate standpoint, because it's a risk reducing mechanism. There's a lot, we had several different dockets opened up on this topic since I've been here, talking about the pros and cons associated with decoupling. MEEIA allows, again, lost revenue recovery. It could go through decoupling. It'd probably be more accurate to call it an LRAM, I think is the term of art that like ACEEE and others would use, which is a lost revenue adjustment mechanism. The big problem with it, as Ms. Lange articulated, is there's a lot of confounding variables when you're trying to isolate for the impact of just energy efficiency by itself. So weather, the economy, load growth, one way or the other, a pandemic, right? All of these things are going to naturally influence load one way or the other. Now you add on pricing mechanisms with time of use rates, and you can see where and I generally don't get too deep in the weeds with the TD mechanism. There's a lot of other real estate to cover in MEEIA, but you can see how it can be a challenge. And to the extent when staff talks about trying to simplify this process and reserving the right to get better, that's where we are in our present situation. So I'm hoping I answered the question.
Thanks, and I've got another question.
Okay.
Well, if you don't mind if I switch gears for just a second. If the commission went through and authorized the throughput disincentive mechanism, what, in your opinion, would be appropriate changes to account for all the different circumstances that have occurred since that mechanism was first, I guess, conceived and put into place?
So it's a really good question. The cleanest, not necessarily the easiest, but the cleanest way to do it would be statutory changes. I mean, we introduce, the statewide program, and we just specifically, spell out decoupling for energy efficiency programs associated with that. There are ways forward that simplify this process considerably. Absent that, our office's position is to support staff's number, because ultimately we believe that more accurately reflects the reality of what's taking place. I'm not an attorney, so, I'm not going to opine one way or the other over the legal ramifications of whether the MEEIA statute, because it predates the PISA statute, supersedes that provision or not. That's not my wheelhouse.
Thank you. And then I'm trying to connect the throughput disincentive mechanism to how it's measured, evaluated, and verified. And I mean, your thoughts on how it's currently conceived to do that, and I think what I'm getting at is with the technical resource manual being a big part of the data pool for that measurement, at least. And can you talk about your thoughts on how you view that process, and I guess how that process might reflect what really happens in practice?
Yeah, absolutely. Are you familiar with, back in the day where people would go to, I guess Lowe's still does it, Lowe's and Home Depot, but, I always think about, like Sears, you would go to a store, you'd see the, refrigerators or dryers, washers, and you'd see that yellow Energy Star sign. It would say, on average, this model will save you, $10 more for an average home. And it's got a score. It's got an Energy Star score. It might go, up to 100, might go, much lower. And people use that as sort of a bandwidth to understand whether something's more efficient or not. That's an example of just an engineer estimate, right? There's a lot of assumptions that go into that Energy Star score. Because obviously, the climate patterns in southern Missouri is going to be very different than the climate patterns in northern Missouri. And the Energy Star is even more pronounced because it's going across the United States. But that's effectively how a TRM works. It's an it's an engineer estimate of, averaging across, multiple different studies. We think that this measure will perform like this. And again, it's making a lot of assumptions. It's assuming that it's being installed correctly, that it's being, tuned up throughout the life of that measure, that it's not interacting, its impact in interacting with other measures isn't offsetting those savings. So on one hand, there's one reality where, this is a sort of a criticism I'd level at, the Department of Energy. When they pass a standard, they might say, well, hey, we just increased the standard of toasters, and this is going to save customers, $1 trillion. That's operating under a lot of different assumptions. And what you find with energy efficiency is that you hit a point of diminishing returns with some measures. So in a vacuum, an HVAC might perform, is supposed to perform at a certain level, but operationally, that HVAC savings assumption's dependent on good ductwork. It's dependent on it being right-sized. It's dependent on all of these other factors. Now, historically, how we have approached EM&V is we haven't had many hard questions about those assumptions on the TRM side. The TRM, we've largely leaned on other states and other models, as well as our own independent research, again, in averages. It's been the second part of that EM&V. Yeah, let me pause real quick there, because that TRM is critically important because it helps inform the lost revenues and the dollar amount that's associated with that. It helps inform ultimately the earnings opportunity that's associated with that. And as Ameren talked about, I think yesterday, was citing the Illinois study where it's just thousands of pages of text. The way to best look at it is it's a living document, and it's constantly evolving and getting better. But reasonable minds can and do differ. So that process can lead to regulatory stagnation and ultimately, contentious regulatory settings where we're taking stuff in front of the commission. We've avoided that to a larger extent these last 3 years because of the one-year extensions. But again, it's come with trade-offs. Like, we've had to concede certain assumptions as a result of that. I'm not sure that's sustainable long-term. I guess I'll leave it at that. Hopefully I answered your question.
Do you think with really what I think is a pretty broad deployment of ANI that's a much richer data stream to actually calculate what the energy savings were? I mean, you don't have to calculate it. I think you can measure it that way.
You can't.
Am I thinking about that wrong?
No, you're not. I mean, that would be a rich data point to move from. And we've had some preliminary discussions in the past about how AMI can help inform EM&V, and it absolutely should. We're going to be talking about programs here in a little bit, and I might be able to provide some more context with that, with one particular program that sheds some light on how bill impacts are directly related to the savings assumptions, and that's PACE, the PACE program. But here's the challenge I would put out there. There is data sensitivity issues associated with that. None of these are insurmountable, but you also hit a point where there's 1 million+ customers. How do you control for this? There would be a lot of sense making associated with how to move forward with that. And I'm not saying it can't be done, but those conversations haven't taken place to date. To any real extent. And again, you got to control for other confounding variables. So if right now customers can switch rate plans, customers, that's going to have an impact ultimately on what takes place here. And at a certain point, this is sort of my own biased perspective on this. I get a point of just kind of throwing my hands up in the air and saying, how certain do we need to be? And you hit that point of starting to do some mental gymnastics and just accept some certain assumptions. The problem, again, is that we feel like we're at a point now where it's just too darn rich, and we're not very confident with ultimately that this will lead to the supply side deferral in a meaningful manner.
Thank you.
Commissioner Mitchell, thank you. Any further bench questions? Hearing none, let me see if we have any recross based on bench questions. Ms. Johnson.
Nothing from staff.
Thank you. Renew Missouri.
Nothing for Renew Missouri, thank you.
NRDC.
None, thank you.
Ameren, Missouri.
Yeah, I just have a few clarifying questions. Good morning, Dr. Mark.
Good morning.
Would you agree with me that the throughput disincentive is trued up using the actual EM&V energy savings?
Yes.
And I think we discussed yesterday, for the company's programs, EM&V, as it stands today, accounts for net to gross.
Yes.
And then, would you also agree, you were talking about using deemed savings to measure the savings, but would you also agree that actual program results also go into that calculation and that data is also used? Or
I would say yes with a qualifying statement to follow up with that. We use both, so each EM&V does reset. We do look at the measures. The reality of it is we can't look at every measure. We can't look at every program in great detail. There's a finite amount of money we can spend on consultants to go ahead in any given area. So we kind of pick and choose our issues, I guess is the best way to describe it.
Yeah, but the actual program results is something that the company also considers in analyzing it. Would you agree in some of the discussions you've had with them?
And the only thing that I would counter or push back on that is that is historically true. We are raising a number of different issues in this case that have not historically been looked at in EM&V, and we say effectively they need to.
You know, I
Okay.
understand that. I just want to clarify, though, you know, that was the point. Your Honor, I have no further questions.
Thank you. Redirect?
Just very briefly, Judge. Dr. Mark, you just mentioned in your discussion with Ameren that there are a number of issues not historically considered. I believe it was in the net to gross. Do you remember that?
That's correct.
Okay, and those issues are things like the rebound effect, the interactive effects, the principal agent issue that are included in our list of issues and in your testimonies. Is that correct?
That is correct.
Nothing further, Judge.
Ms. Van Gerpen, thank you. Dr. Mark, thank you. And this appears to be a good natural time to take a break. And I think I had asked counsel earlier about moving on to the next issue, and I think you indicated you might need a little time to contact witnesses, get them available. Do you have an idea about how much break you would like to get ready for the next issue?
Judge, if we could, I think the OPC would like to have until after lunch, even if we do an early lunch.
Okay, and that's kind of what I was wondering, if like maybe something more like 12:30, 1 o'clock, if that would suffice.
That'd be fine with us.
Thank you. Any disagreement or comments? Anybody need more time, or will 12:30 work?
Judge, this is Sarah Rubenstein. NRDC's witness would appreciate after lunch as well.
Ms. Rubenstein, thank you. Would something like 12:30 or so work for you?
That should work great.
Very good, thank you.
Thanks.
Anything, and then we'll plan to be on break then until 12:30, and then start with the last issue and see how far we get today. Anything further from council or from the bench before we take a break? All right, hearing nothing further, we will be in recess until 12:30. Thank you very much. We are off the record. Right, Madam Court Reporter, are you ready? Brian, are we ready? All right, good afternoon. We are back on the record. I believe we are ready for opening statements for programs, which is the final issue on the list of issues. Does council need to bring anything to my attention before we proceed to those opening statements?
Yes, Judge. Not 100% sure we need to take judicial notice of it, but I have seen arguments about this in the past. So staff would like to request judicial notice of the report and order in docket EO 2015-0055. That is a pretty long docket, and the EFIS number is 289, and it was filed on October 22nd, 2015.
Any objections to that?
Could I have a clarification? Are you just admitting the report and order? I thought you,
Yes, just the report and order.
okay, you threw me off. Aaron, I just want a point of clarification, though. There's no objection to the commission taking judicial notice, but I want to make it clear that the other parties do not have to, it's not necessary if we're going to use a different docket to reference, to have the judge, Your Honor, take judicial notice of that as well. Or, yeah, or just, to cite to the report and order.
Sure.
In the briefs.
Okay, thank you. The commission will take judicial notice of its report and order in file number EO 2015-0055. Anything further before we proceed to openings?
Nothing from staff, Judge. Thank you.
All right. Ameren, Missouri, whenever you're ready.
Thank you, Your Honor. May it please the commission, I'm Jennifer Moore, appearing on behalf of Ameren, Missouri again. This week, the hearings have focused on many details filtered through the perspectives of many parties. As we discuss the program section, I do not want to lose focus on the goal of energy efficiency. So this week, we've dedicated a lot of time to the earnings opportunity subsection of MEEIA, and that goal should, but we've lost sight of the goal that should be given the most weight. And that is that the commission must ensure that financial incentives are aligned with helping customers use energy more efficiently and in a manner that sustains or enhances utility customers to use energy more efficiency. When we talk about the MEEIA portfolio or the programs, we are talking about how each program helps customers use energy more efficiently and in a manner that sustains customers' incentives to use energy more efficiently. And what this does, it gives customers control over their usage and their bills. The company incents customers to use energy more efficiently through these programs. We talked about how the HVAC program being a step into the residential demand response program or vice versa. These programs complement each other and offer demand and energy savings. The company needs both demand and energy savings as tools in its reliability toolkit in order to help customers use energy more efficiently. There needs to be programs that appeal to a diverse group of customers, and these customers need tools like energy efficiency to help them control their bill. To accomplish this goal, the commission shall permit electric corporations to implement commission-approved demand-side programs proposed pursuant to MEEIA with a goal of achieving cost-effective demand-side savings. The more diverse the portfolio, the ability to reach more customers is increased. The more customer sees a savings on its bill, the more the customer is likely to be incentivized to use energy efficiency and go around and start turning off fans and lights. Because of these programs, will create in the past and in this program, it's been estimated that they will create approximately 2,700 jobs. And whether that's an engineer helping a small business customer use energy more efficiently, or families hoping to reduce their usage in order to minimize their bill. Like all portfolios, some programs become more popular while others are less popular during the term of the cycle. Please ask Mr. Lozano and Mr. Vai about how they need to manage the portfolio so that programs that are experienced in demand continue to be utilized by those customers, and how they use maybe some budget dollars from other programs who aren't doing so well so that they can keep those other programs running. This is not gaming the system, but rather it's managing a portfolio to encourage participation and to deliver as many benefits as possible to our customers. Mr. Vai led the design of the portfolio, and I encourage the commission to ask about the related challenges and opportunities in managing that portfolio. The company's portfolio is cost-effective with a TRC ratio of 1.4. The portfolio is another tool in the reliability toolbox for the company to rely on to meet its resource needs and the tools for customers to control their bill. We are requesting that these programs be approved so that we can encourage our customers to use energy more efficiently. Are there any questions? That concludes my comments.
Ms. Moore, thank you. Any bench questions? All right, hearing none. Ms. Moore, thank you.
Thank you.
Any opening from staff?
Yes, Judge.
Mr. Pringle, when you're ready. Chair Hahn, I'm sorry, I think you had a question.
Yeah, sorry for Ameren Council. We've spent some time looking, we're trying to figure out which MEEIA 3 programs are still in existence. It's kind of hard to tell with the extensions. Would it be possible to either admit that at some point or provide that information, or who should I ask?
I think what you're asking are what are our current programs under the program year 2024 extension, and those are all outlined in the stipulation and settlement. And I believe Mr. Lozano might have a list too. So I think in our extension, for example, I know we don't have educational toolkits. I remember that because my daughter came home excited with one, and so but that's not in 2024. Those are no longer, we're not offering those now, but I think they went back into the portfolio.
Thank you.
You're welcome.
All right, Mr. Pringle, when you're ready, sir.
Thank you, Judge. Judge Pridgen, Chair Hahn, Commissioners, may it please the Commission. We have reached the end. We've discussed the lack of details in Ameren's application and how that lack of detail impacts every part of the application. This lack of detail extends to the tariff program submitted by Ameren, and as staff has noted throughout, the devil is in the details, and these tariffs are sorely lacking. The Commission should reject Ameren's proposed tariff programs. The rejection of a given application is not an attack on the benefits of ratepayers utilizing electricity more efficiently, but rather an indication that the programs offered by a utility in a given application are just not reasonable, not well supported, and or did not meet the various requirements that must be achieved prior to approval and cost recovery from all ratepayers. In this case, Ameren's application fails to address any of these 3 concerns. Since the utility profits without spending shareholder dollars in MEEIA programs, it is imperative that the estimated benefits to ratepayers identified in a MEEIA application are reasonable and well supported, and that the tariffs are detailed enough to drive actual ratepayer benefits. In this application, there is insufficient support for the Commission to make the conclusion that ratepayers are better off paying for the MEEIA 4 plan regardless of their participation. Ameren Missouri shareholders are incentivized to invest in additional generation resources through a rate of return in traditional rate making. Designing energy efficiency programs that are ineffective in deferring, reducing, or avoiding those investments benefits shareholders to the detriment of ratepayers. Ameren's programs are currently designed to manage to the metric, not to benefit all ratepayers. The broad language that Ameren is requesting you approve provides it nearly unfettered discretion and flexibility in benefiting Ameren, not ratepayers. Without the modifications requested by staff, Ameren is disincentivized from implementing programs that actually align with ratepayer benefits. On this issue, you'll be hearing from staff witnesses Jordan Hall, Marina Stever, Amy Eichholz, Mark Kiesling, and Jay Lubert. Jordan Hall has put forward testimony addressing aspects of aggregator or retail customers, also called ARCs, Ameren's Business Demand Response Program, and the MISO Planning Resource Auction. Ms. Stever has put forward testimony presenting and summarizing the costs incurred to date and those projected through the end of 2024 associated with Ameren's MEEIA program. Ms. Eichels has put forward testimony outlining staff's concerns with Ameren's income-eligible programs. Mr. Kiesling has put forward testimony outlining staff's concern with Ameren's residential and business programs. On the residential side, Mr. Kiesling addresses the residential new construction, the residential demand response, specifically the continued incentivization of new thermostats, and the education energy efficiency kits. On the business side, he has testimony addressing concerns with Ameren's lighting and demand response programs. Finally, you will hear once more from Staff Witness Jay Lubert, who will take the stand to address staff's overall concern with the tariff programs, as well as how the seasonality of the MISO Planning Resource Auction must be taken into account when designing demand response programs. Please ask them any questions about their topics. They are here to help you and inform you as you reach a decision on this issue. Now, though the staff does recommend rejection, if the Commission does approve any part of Ameren's application, it is essential that the tariff sheets be modified. At the very least, the exemplar tariffs within the application's Appendix J must be modified to include the following. First, a description of the purpose of the program, including the desired outcomes of implementation. Second, descriptions of availability for each program. Third, clear definitions of terms within the program. 4, program-level budget by year broken down by cost categories, such as incentive amounts, administration, labor, measurement, and verification. 5th, energy efficiency measures that are available through each program. 6, the incentive amount for each measure through each program. 7, description of the recovery of program administration, the purpose, the availability, descriptions, incentive amounts, applicable rates, and those restrictions. And finally, an explanation of the evaluation of each program, including, but not limited to, how achieved savings will be measured or verified, and the determination of goals achieved through program implementation. Thank you for your time this week, and I am happy to take any questions you may have.
Mr. Pringle, thank you. Any bench questions? Hearing none, thank you very much. Any opening from Renew Missouri?
Judge, I have no opening on this topic, thank you.
Thank you. Any opening on behalf of NRDC?
Yes, Judge, I have an opening statement.
Whenever you're ready.
Good afternoon. May it please the Commission. I'm Sarah Rubenstein, again here representing NRDC. NRDC respectfully asks that the Commission approve Ameren, Missouri's proposed MEEIA Energy Efficiency Plan with modifications. As is explained in the direct and rebuttal testimony of Stacey Sherwood, the plan has good attributes, putting forward a wide-ranging portfolio of programs and measures across different rate-paying classes. However, as the projected demand savings from the program drop off after 2025, NRDC believes the plan leaves room for improvement. Ms. Sherwood's testimony recommends modifications to the programmatic elements of the plan that would expand its reach and increase its demand savings opportunities. First, Ms. Sherwood's testimony explains that the plan should be expanded to reach a minimum of 1% annual energy savings, an additional cost-effective annual energy savings that may be available to bring the program closer to the level of savings projected by the Commission's MEEIA demand-side savings goals of 1.9%, closer to cost savings achieved by other similarly situated large electric utilities in excess of 1%, and closer to levels Ameren itself achieved in prior years of 0.99%. Second, Ms. Sherwood calls for the plan to be modified to limit residential lighting programs to direct installation in income-eligible properties and to use a measure life assumption of 1 year. The high-efficiency lighting discounts proposed in the plan are no longer necessary in light of the fact that LEDs now serve as the baseline. Third, Ms. Sherwood's testimony calls for expansions of the company's residential demand response program to offer winter demand response opportunities and to include small business customers. Ms. Sherwood suggests that this could be accomplished by expanding the current residential smart thermostat program to include winter events and by expanding the entire program to reach small businesses. Finally, Ms. Sherwood recommends braiding or leveraging programs that promote the common goal of reducing energy consumption and demand with MEEIA programs rather than supplanting them. She believes this will be especially beneficial because cost is one of the greatest barriers to the implementation of energy efficiency measures for both households and businesses. Thank you very much.
Ms. Rubenstein, thank you. Any bench questions? I think I might have one or two procedural questions. Ms. Rubenstein, is Ms. Sherwood taking the stand?
She is, yes.
Okay, I do not see her on the list of witnesses. I have no problem at all with her testifying. I guess, trying to figure out where she would go in the witnesses, in the order of witnesses, assuming no counsel objects.
Yeah, no objection. I believe that was an oversight. We were trying to get the document filed timely.
And, yeah, it's like I said, I certainly have no problem. I guess I'll just, I don't have to have the answer right now. I just kind of want to know where she should fit in the schedule. I mean, we could do last or somewhere in between it. If council want to kick it around at the break or something, that's fine with me.
I guess Judge Staff will throw it out there. I think it'd be appropriate if Ms. Sherwood wants to take the stand following the conclusion of Ameren's case.
Okay.
OPC agrees with that.
Any objections or any concerns with that?
That should be fine.
Okay, so Ms. Sherwood would take the stand after Mr. Huber and before Mr. Hall.
Great.
All right, very good. Thank you.
Your Honor, if I may make a clarification
Sure.
to the communication I had with Chair Hahn. While it is the stipulation and settlement in docket 2018-0211, it is listed as item 230, and it was filed on August 23rd. However, in looking at it, it has old measures that weren't, old programs that are no longer, that weren't included in this cycle. So we are preparing you a sheet, and if you'd like us to offer it as as an exhibit into the evidence, we can have that filed on EFIS. Or move to admit it.
That'd be wonderful. Thank you.
All right, Ms. Moore, thank you. Opening from Public Counsel.
Yes, thank you, Judge.
And Ms. Van Gerpen, when you're ready.
Good afternoon, Chair Hahn, Judge Pridgen, Commissioners. May it please the Commission. For the last issue, we're going to talk about the programs that Ameren proposes as part of its amended application. Again, the OPC believes that you should reject the entirety of the amended application. We've discussed many reasons why throughout this week, and Dr. Mark's pre-filed testimony addresses many of those issues further and in greater detail. But the deficiencies in many of Ameren's proposed programs stands as yet another reason for this commission to reject the amended application. However, if you conclude that Ameren should be allowed to offer MEEIA programs, the OPC has two alternative proposals for your consideration. First, Dr. Mark has described a quote-unquote MEEIA light portfolio in his Sir rebuttal testimony. Much like the negotiated one-year extensions, this portfolio trims the fat from Ameren's proposal in the amended application. It allows Ameren to offer 5 programs over the next 2 years, and those programs include an income-eligible multifamily program, a modified residential pays program, business demand response, residential demand response, and business standard non-lighting. If the Commission approves this MEEIA Light portfolio, then it should serve as a bridge over the next 2 years as the parties work together toward a statewide program. Alternatively, Commissioners, throughout his rebuttal testimony, Dr. Mark suggests modifications to, and in some cases, total elimination of, certain programs that Ameren has proposed in its amended application. For instance, he explains how some programs are known to be full of free riders, and how others fail to account for progress made during the extension years. As we've discussed throughout this week, MEEIA programs must evolve over time. Dr. Mark has a history of helping these programs to do so. If you decide to approve some of Ameren's proposed programs, his suggestions will help that evolution continue, and we ask that you adopt them. Compared to Ameren's amended application, both of these portfolios are more aligned with the public interest and help to ensure that customers actually receive a benefit for the large investment that they are required to make in energy efficiency. However, again, we ask that you reject the amended application, not only because of the deficient programs, but also for all of the reasons that we have discussed this week. Again, I ask you to ask Dr. Mark any questions that you have, and I'm happy to take any questions as well.
Ms. Van Gerpen, thank you. Any bench questions? All right, thank you.
Thank you.
I believe we're ready to go to Ameren witness, Mr. Vi, if I'm pronouncing that correctly.
That's correct. I would just, we had discussed before the break, lunch break, to think on, how we wanted to do the discussion with the 11-step process. I would propose that we take Mr. Vi in order as on the list, but then be able to recall him at the end after all the witnesses, just to discuss that one particular 11-step process.
Okay. Any objections?
No objection from staff, Judge.
All right. Mr. Vi, have you been sworn yet, sir?
Yes, I have.
Okay, very good. You're still under oath. And anything from Ameren, Missouri before he stands cross-examination?
Not at this time. We tender him for cross.
Okay, very good. Cross-examination, Renew, Missouri.
None for Renew Missouri. Thank you, Judge.
Thank you. Any cross from NRDC?
No, Judge, thank you.
Thank you. Any cross from staff?
Yes, Judge, thank you. Good afternoon, Mr. Vi.
Good afternoon.
And I kind of want to talk to you about the demand response programs real quick. With the residential demand response, there is no opt-out option, correct?
Yes, that's correct. Residential customers are not allowed to opt out of energy efficiency.
But on the business side, customers are allowed to opt out, correct?
Yes, there are certain criteria that's outlined within our plan on the criteria for how business customers can opt out. But as part of our stipulation, they are able to participate in our business demand response program.
Are you, and well, I guess so, when they do opt out, what does that mean?
I'm not the best person to address that. Potentially could be Tony Lozano on our team.
And are you aware how many Ameren customers choose to opt out of the business demand response program?
The number is updated in our filing, but I can't recall from hand, but it is part of our filing.
Do you know where in the filing that could be found?
I think there's a business opt-out under business programs or whatnot section, but I would have to find it.
One moment, Judge. And going back to the residential side, Mr. Vi, which measures are eligible through the Residential Efficient Products Program?
Those measures are part of what we filed as part of the similitude in our plan. I do not know exactly all the measures that are offered.
And you said that was in the submittal tool. Where can these measures be found in the tariffs?
Those measures are not listed in the tariff, but they are listed on our website. Per what we've worked out is the measure plus incentives are included and listed on our website.
So they're just listed on the website, but not in the tariff?
No, I think the tariff refers to the website where they can actually receive the incentive.
Then also, if a reference to the incentive range document within Appendix D, scratch that. So are all the measures included in the appendix, are they all going to be available?
Can you repeat that question, please?
So pretty much all the measures, I guess let's talk about actually the website instead. All those measures listed on the website, they will all be available.
Yes, that's correct.
Okay. And then also, when it comes to the deemed savings tables, are all those measures going to be available?
If those measures are part of the programs the existing programs that we're implementing, they will be available.
And then also when it comes to, let's say, the design, implementation, and impact of the demand response programs, are you the best witness to ask those questions, or who should I ask those to?
As far as our witnesses, I think I can respond to those questions.
Okay. So what are the what hours does Ameren target as most likely to coincide with the MISO Public Resource Auction spring peak hours?
That I do not know. I would not be able to address that question.
Do you know if there's a witness who can?
I would look to either Tony Lozado or Steve Wills.
And would you be able to answer that same question for the fall peak hours?
That would be my same response.
And for the winter peak hours?
That would be the same response.
Thank you, Mr. Vai. No further questions, Judge.
All right, thank you. Any cross from public counsel?
No, thank you.
All right, thank you. Any bench questions?
Yeah, just Commissioner Kochmeyer, just for the record, I'm on the WebEx.
Good afternoon and welcome. Any questions from the bench?
Judge, one here.
When you're ready.
Thanks, Mr. Vai. Just taking lead from your counsel, can you talk about how you manage the portfolio of programs in regards to sort of mix and matching and adjusting the buckets of the programs, and you know what the challenges and opportunities in managing the portfolio would be if it's approved?
Yes, I explained in my testimony, but to simplify things, the process that we go through to build out our portfolio included first working with our implementer a market potential study that gives us a snapshot of the opportunity that we have for energy efficiency. We look at that data, and that data is incorporated into our integrated resource plan that develops a preferred plan, which includes our DSM plan of energy efficiency, DR. We did take those inputs and we sent out those targets to the market in the form of a robust RFP process. Part of that RFP process that we incorporated, we received 40 proposals, over 40 proposals on programs designed to possibly be incorporated into our plan to meet those energy and demand needs. From that, we worked and chose our top selected implementers, and with those proposals, developed a plan. That plan inserts each sector of that plan. We provided in presentations to staff, state and OPC and other stakeholders to identify what we've received from the market and what we looking to include in the plan to get feedback upon that. Upon that, we build out our plan. The goal of our plan as we put it together is a couple of things. One is to maximize the benefits for our customers. Two is to maximize participation for our customers. As staff alluded to earlier, our customers, majority of our customers, other than our large industrial customers, are not able to opt out, which means that that they will be paying the energy efficiency charge. So we see it as an opportunity to design cost-effective programs where more of our customers can participate. And that's how we put together the different plans. So to maximize participation, but still keeping in mind making the programs cost-effective, as well as maximizing benefits for our customers.
Thank you. And I'm just trying to understand how this would work if you identify programs that are underperforming. Can resources then be shifted to the elements of the program that are performing well? And if the answer to that question is yes, is there some adjustment in the overall cost of the program?
Well, as I stated before, we look from best practices from our implementers on programs. I think that's where we talked about the incentive range we filed. We have the opportunity to shift those incentive range to get better participation from that. In order to shift that, we do have the 11-step process that's included that we will work with staff and OPC and others before making those incentive ranges. It spoke to earlier from staff the question about why not including those incentives within the tariffs. As we looked at it, and I know we'll get into it later with the 11-step process, but we've had over 28 11-step processes enacted through MEEIA. What that gives affords us the opportunity to work with stakeholders, gain approval or guidance to move forward with incentive changes and make those incentive changes without having to refile tariffs. You think about that, if we had to refile 28 times, that's 28 times that you as commissioners will have to rule on and approve that tariff change and going through that process. So we saw this as part of MEEIA 3 as a way to simplify the process, still get buy-in from all stakeholders, and move forward and make the process more efficient for all.
Thanks so much. That helps me. I'm looking forward to hearing more about the 11-step process a little bit later. Thank you.
Commissioner Mitchell, thank you. Any further bench questions? Hearing none, any recross based on bench questions from Renew Missouri?
No, thank you, Judge.
From NRDC?
No, thank you, Judge.
Staff?
Yes, Judge, thank you. Mr. Vai, going back to Commissioner Mitchell's questions, how many implementers does Ameren employ or contract with?
We currently have 2 prime implementers. We have an implementer that implements our residential program, prime implementer, and we also have a prime implementer on our business program, and then we have a prime implementer that oversees the EMV process. And these implementers, they may have sub-implementers to implement certain aspects of our portfolio of different programs.
But you're not aware of how many sub-implementers they may have?
As far as sub-implementer, I can't recall the exact number. If you give me a specific program, I can recite who's that implementer is that is working with our prime to implement that program.
That's fine, Mr. Vai. Also, do you know how many evaluators Ameren employs or contracts with?
We have, at this current time, we have 1 evaluator that implements that portion of our program.
you know-
that portion of the program that completes the M&V analysis.
Do you know what is the cost to Ameren for the implementers you described earlier?
As part of we have the cost estimated. I think we estimated the cost at being 3% within our portfolio. That cost is identified in Appendix A. Past evaluations, you can see from the final M&V reports that has the final implementation cost is included in those final reports.
And how about the cost for the evaluators?
Similar, that those are included in Appendix A. I'm sorry, I might have misspoke when I talked about implementation contract. It's not as 3%. The evaluator's implementation cost is modeled at 3%. The implementation is modeled at the percentage based on those portfolios.
Okay. And so when you say 3%, is that 3% of $370 million?
Yes, that's the estimate that we have for our evaluation contractors, and per MEEIA, we're allowed to go up to 5%, but we've been able to create efficiencies to get it down to 3%.
And then also, you talked about top implementers. How does the company choose top implementers?
Like, as I mentioned, we go out for a robust RFP process, and we have evaluation of those processes based on various things based on their experience in our territory, the types of programs they implement, cost. So it's a lot of factors that comes into play, and then we hire the best implementer to implement for our portfolio.
Do you know, do implementers ever propose new programs to Ameren?
Yes, we received proposals. I think it was over 50 new programs that were proposed for this cycle from implementers. Part of that is what we propose is a new pilot innovative type process, so we could potentially review those and bring them up to the top, or which one is maybe more effective to bring into our portfolio.
So, if I'm understanding you correctly, Mr. Vai, any programs not currently offered by Ameren, proposed by implementers, they would fall under that pilot program that's being proposed, correct?
Well, the pilot is a process to propose. That proposal includes evaluating those programs, what's the opportunity of those programs, and there's also an opportunity for feedback and interaction with our stakeholders before moving forward and actually implementing those programs.
Are you aware of what % of project spend the pilot program is?
I'm not familiar, but that is also in Appendix A.
Thank you, Mr. Vai. No further questions from staff, Judge.
All right, thank you. Any cross from public counsel?
No, thank you.
Redirect?
Just a few, thank you. I want to take us back to the question that Commissioner Mitchell asked. And he asked about moving dollars from one program to another to help underperforming programs, or you discussed that with him. If Ameren, Missouri does not spend those dollars that are moved, does Ameren, Missouri recover those dollars through the EEIC?
No, we only recover dollars that are used as part of implementation of those programs.
So the actual program costs are trued up in the rider?
Yes, they are.
That's all the questions, thank you.
Ms. Hernandez, thank you. Mr. Vai, thank you. You may step down. I believe Mr. Lozano is the next witness.
That is correct, Your Honor.
And Mr. Lozano, you are still under oath. Anything from Ameren, Missouri before he stands cross-examination?
Your Honor, the company tenders Mr. Lozano for cross-examination. He's been previously sworn.
Thank you. Cross-examination from Renew, Missouri.
No, thank you, Judge.
Thank you. From NRDC.
No, thank you, Judge.
Staff.
Yes, Judge, thank you. Good afternoon, Mr. Lozano.
Good afternoon.
Were you here for Mr. Vai's testimony just a moment ago?
Yes, sir,
There were a few questions he told me to ask you, so I'm just going to throw them your way.
for sure.
What are the hours, well, what hours does Ameren target as most likely to coincide with the MISO Planning Resource Auction spring peak hours?
To be clear, when you say does Ameren target for what?
Well, this is going to be for, well, with the MEEIA planning purposes.
Yep. I've thought about this a little bit. I heard you asking them the questions for the different seasons. Since this ties to the broader reliability strategy of the company, I can speak a bit from a MEEIA perspective, but I think that would be best for Mr. Wills, who's coming up right after me, so we can give you the most comprehensive answer.
All right, well, I guess then, are you aware of what the hours are currently that they're being targeted for MEEIA purposes?
Not off the top of my head.
All right. Well, then, do you know what the demand reduction capability of the demand response programs will be for, well, just for the purpose of the spring MISO planning resource auction in 2025?
For the spring auction, again, not off the top of my head. We can get that for you. I would be happy to.
In one moment, Judge. Thank you for your time, Mr. Lozano. No further questions.
Thank you. Any cross from public counsel?
No, thank you.
Thank you. Any bench questions? Hearing none, I think I have just a few. Mr. Lozano, if the commission were to cap the 2025 to 2027 MEEIA costs to the levels of the prior plan, are there programs that Ameren would want to eliminate, or would it just reduce each program cost equally?
Thank you for the question. Certainly, we would not look at that equally across the board, and I think there are a couple very important reasons for that. Mainly because the efficacy of all programs are not equal. So we'd want to look at the reach and the impact of the programs and the cost effectiveness of each program. That's probably the most comprehensive answer I can give you, or the concise answer.
Well, thank you. And this may already be in pre-filed testimony, and if so, please, just refer me to that. But is Ameren able to rank the proposed 2025 to 2027 programs in order of the greatest savings, percentage, of cost, like most to least, or is that somewhere else in pre-filed?
And to make sure I understand your question so I can answer it, are you asking from a cost effectiveness standpoint, or from an energy savings or a demand savings, or maybe a conglomeration of all above?
Mostly cost, but I mean, if you have other rankings, that would also help.
We can certainly do it from a cost effectiveness standpoint, from a TRC standpoint, and then we could absolutely then say what are the energy savings and what are the demand savings as well. Absolutely. I apologize, just maybe if I can add a little bit to that. When we look at the total resource cost test, one of the reasons why that is such an impactful view is because it does take into account those proposed energy and demand savings, as well as what the costs are, and those energy and demand savings are what drives that benefit. So if we looked at it from that perspective, that would be a good view.
With the information and products that customers have to reduce energy usage, why does Ameren, Missouri think that its customers need this pending MEEIA 4 plan and the costs that go with it?
I think that's a great question. Mainly, reliability today is strained, and we need, from a resource perspective, supply and demand side, we need to continue to tap into. I'm going to use Ms. Moore's phrase earlier. All the cost-effective tools in the toolkit that we can. We know this has been effective for over a decade, and we know if we design it well and then we deliver it well, it can continue to be not only cost-effective but really impactful from a lot of non-energy benefits as well. And it absolutely can and should be part of that solution when we think about the reliability in the state going forward.
Does the level of free ridership indicate that Ameren, Missouri customers don't even need this MEEIA plan in the first place?
The short answer is no. And as we continue to, Mr. Grazier has provided a lot of testimony from an EMV perspective. I know there wasn't much discussion yesterday on that with him. But as we continue to go through that process, I would just encourage that we continue to make sure that the opportunity for evaluating that and taking that into account within that process would be there. So to the extent that changed, that we would understand that and we would adjust accordingly.
If Ameren, Missouri's prior MEEIA plans were effective, why is this MEEIA plan even needed?
From a macro level perspective, we've heard a lot about the clean energy transition. We've heard a lot about load changing and load growing, and those things will continue to happen. I don't want to get too ambiguous with my answer here, but when we think about the demand response side, and Chair Hahn, you were asking me questions about demand response specifically and what role it can play in reliability. It absolutely can. Energy efficiency also can play a role in reliability. And I think that is going to be needed as, I should put my hands down and just talk, as that equation continues to get tighter and tighter and tighter, the need to balance that equation will become even more and more important in the coming years. So from a reliability perspective, I think that's important. From an energy efficiency perspective, I'm going to tie back to my continuous improvement in lean days. What is that doing? That is looking at what are the opportunities we have out there on the, I'm going to use the word system generically, on the system, and that is taking away potential waste on the system and making the system as a whole more efficient. Regardless of technology changing and regardless of updating systems and humans putting different processes in place, new waste will always be there. And the reason why energy efficiency is important, it helps to reduce that and make, no pun intended, make the system more efficient. So we can help that become more efficient. We know it's cost effective. And at the same time, with that supply-demand equation getting tighter, we can help that balance as well.
Great. Mr. Lozano, thank you. Let me see if we have any recross based on bench questions. Any cross from Renew Missouri?
None, thank you, Judge.
Thank you. Any from NRDC?
No, thank you, Judge.
From staff?
Yes, Judge, thank you. Going back to some of your responses to the bench, Mr. Lozano, are you aware of specific language in the MEEIA rules that limits non-energy benefits?
I'm thinking through this right now. I'm picturing the rules in my head. I know that non-energy benefits, we do not include that in our total resource cost test. I know that. I'm also aware that non-energy benefits are laid out in the MEEIA rules by three categories. One is for the customers.
Well, actually, since you brought the TRC, actually, that helps with my next question. Does the TRC consider program costs?
So I can speak to that at a high level. I think Mr. Brueggemann's probably the better person to talk to that. The TRC, from a cost perspective, it does have administrative cost. It does have the participant cost, which is, how much you're going above the baseline. From a benefit perspective, it includes the avoided costs, and it compares those two.
But does it consider the program costs?
Yeah, I believe the program costs are in those administrative costs.
So does it consider incentive costs?
This is where it gets a little bit outside of my area of expertise, but the way the explanation is understanding is when you talk about those participant costs and where you're going above the baseline, that's where I think Mr. Brueggemann would be best to explain that, and he is coming up.
Okay, and then, well, I guess would he be best for, does the TRC consider TD cost?
Yeah, he would absolutely be.
And same thing for earnings opportunity cost?
Yeah, and it does include the earnings opportunity.
And that's a yes for EO.
It is a yes.
Thank you, Mr. Lozano. No further questions, Judge.
Mr. Pringle, thank you. Any recross from public counsel?
No, thank you.
Any redirect?
Yes, Your Honor, thank you. I'm going to start with some questions because they're probably from staff counsel because they're probably fresh in your mind. When you were talking about non-energy benefits, I believe you were cut off. Did you want to continue?
Yeah, I'm picturing the rules, and I'm not going to be able to lay them all out, but there's 3 categories of non-energy benefits that the MEEIA rules state. And the first category relates to customers, and it talks about things like productivity and the like. The second category relates to the company, and it talks about like arrearages and bad debt write-offs. And the third category relates to society as a whole, and it talks about economic development and other items like that. So those are the 3 broader categories that are laid out in the MEEIA rules, none of which we have included in our cost effectiveness testing, but all of which are stated in the MEEIA rules.
And now I want to follow up on some of the questions from Judge Pridgeon. He kind of asked some questions about, why the company wants to do energy efficiency. Is Ameren, Missouri experiencing load growth?
Yes.
And does energy efficiency offset Ameren's load?
Yes. I can give some examples.
Sure.
Yeah, one of the things that's been fascinating to me this week is we've stayed at a really, really high level. And I can understand that to an extent because staying at a high level is, we're trying to make sure strategically things are set up correctly. But we have got thousands and thousands and thousands of examples just over the last couple of years, certainly over the last couple decade or the last decade plus of, let me give you here, Lindbergh High School, who since 2016 has done 13 projects to save $325,000 annually in their bills. This work has, among other things, it supports a new flexible, future-ready learning environment for all those students. Randolph area YMCA in Moberly, not too far away from here, has saved $23,000 annually in their cost. This directly goes to support their scholarship programs. By the way, Randolph area YMCA, 227,000 kilowatt hours a year. Lindbergh High School, 4,051,000 kilowatt hours a year saved. And the thing I struggle with here is either those numbers are completely made up and somebody's paying them every single year for those savings so they can offset those scholarship programs and they can do those other things, or those are real. So something's happening there. And we've got thousands of examples like that. So we can talk about the tactical details and we can talk about the nuances, but those are real. Those impacts are real.
I want to touch upon another question. So, kind of switching gears here. So, if you're saying energy efficiency offsets Ameren's load, isn't it also true that regardless of free ridership, whether you count it or, you know, and where you don't count it, whether you deduct it, free ridership is still out there and the system load is reduced?
You're saying,
So
Excuse me, make sure I understand the
if I'm
question.
a free rider, but I've reduced my usage,
The
doesn't
load
that
still
also
goes
help
down?
reduce the system load? Am I correct in that?
It does.
One last question in terms of, and this might be a better question for Mr. Vai, and that's fine, but when the budgets are set, do certain programs have an economy of scale?
Yes.
And so would administrative costs be the same regardless of the economy of scale? So if you had a large economy of scale with a program and the incentives?
You're saying there are do some
Objection beyond the scope of bench questions?
Ms. Moore?
Well, I don't think so. In my notes here, I have talk about reducing or capping the budget. And if that, you know, is something that the commission's considering, I just want to get more clarity in the record on how those are designed, and just so that there's an understanding of some impacts that might happen.
Yeah, I'll overrule the objection.
I believe what you're asking, are there fixed costs with some
Correct.
programs? Absolutely. And so if the programs get bigger, the percent of administration cost goes down.
And so some programs, I don't know how, give me a moment to phrase it. So some programs, if their budgets are reduced, the projected savings might be reduced as well.
Yes.
But those two numbers don't necessarily correlate. in
Yeah,
the
it's
real
not
world.
linear interpolation.
Yeah.
Yeah.
I have no further questions.
Okay, Ms. Moore, thank you. Mr. Lozano, thank you very much. I believe Mr. Wills is the next witness.
Excuse me, Your Honor, while Mr. Lozano sits down, I'd like to move to offer Ameren Exhibit 105, Ameren Exhibit 106, and Ameren Exhibit 107, and let me identify those. Ameren Exhibit 105 is Mr. Lozano's, again, let me put my reading glasses on and start over. Ameren Exhibit 104 is Mr. Lozano's direct testimony. Ameren Exhibit 105 is Mr. Lozano's rebuttal testimony. And Ameren Exhibit 106 is Mr. Lozano's surrebuttal testimony. So excuse me for that.
And Ms. Moore, you're offering those three exhibits, is that correct?
I'm sorry, could you repeat that?
Sure, you're offering those exhibits?
Yes, Your Honor, but I do want to clarify that 104 has both public and confidential versions.
Okay, so we'll label those as 104 and 104C.
Thank you, Your Honor.
Any objections? Hearing none, exhibits 104, 104C, 105, and 106 are admitted into evidence. And Mr. Wills is on the stand, and you're still under oath. Anything from Ameren before he stands cross-examination?
This is Mr. Will's last time taking the stand, so we would move for admission of exhibit number 102, public and confidential, that's his rebuttal testimony, and exhibit number 103, his surrebuttal testimony.
All right, exhibits 102 and 102C and 103 have been offered. Any objections? Hearing none, exhibits 102, 102C, and 103 are admitted into evidence.
Thank you, and I tender the witness for cross.
All right, Ms. Hernandez, thank you. Any cross from Renew Missouri?
No, thank you, Judge.
Thank you. NRDC?
No, thank you, Judge.
From staff?
Yes, Judge, thank you. Good afternoon, Mr. Wills.
Good afternoon.
And were you present for the testimonies of Mr. Vi and Mr. Lozano?
I was.
All right, so you heard them defer some questions to you.
I did, yes.
All right, so Mr. Wills, what hours does Ameren target as most likely to coincide with the MISO Planning Resource Auction spring peak hours?
So, I think there's a little bit of complexity to this that I want to back up and kind of talk through. But, the way our load gets, our capacity obligation let me also just say about this, I've been hands-on with this in the past. It's been a few years since I was hands-on with it. I'm pretty sure my memory is accurate and consistent with what goes on today. Mr. Michaels would have had some other perspective on pieces of this as well. I think I can do it justice. Just caveating a little bit because, my hands-on activity with this is, has been a couple of years removed. But I'm pretty sure that, most of these details are still going to be accurate. So our spring capacity obligation is going to be based off of our Module E load forecast that we submit to MISO. And so it's a load forecasting process we do annually. It's separate but related from the IRP forecast because the IRP forecast is a snapshot every 3 years. We have to do this annually. But how much capacity we have to, hold or procure in the capacity auction is tied to our Module E forecast by season, so our peak load. And our load forecasting team applies, at least this is when I was doing it, this is how it worked. MISO would publish the peak hours there's, the overall MISO footprint peaked, and we would do a coincidence analysis of our system peak load to the MISO peak load. And then, so whatever, so our peak capacity obligation was driven by our peak load forecast with this this coincidence factor that expressed kind of the relationship between Ameren, Missouri's and MISO's peak load. And so what we know though is that's kind of the annual operational way that we get our capacity obligation in MISO. It's based off of our forecast. So we know our peak load is going to be what that capacity obligation is driven around. So you step back to the planning process, and where that occurs and most robustly is going to be in the integrated resource plan, right? I know you're probably looking at our filing here and you see one coincidence factor for determining the kind of the capacity, the avoided capacity costs. The IRP is much more detailed than that. So what happens in the IRP is we develop a number of different portfolios, RAP, MAP. Mr. Michaels could probably rattle them off, but there was, I think, an 80% of RAP portfolio. Each of those portfolios is shaped on an hourly basis using end-use load shapes specific to the measures that are included in our potential study of RAP. So we have kind of a time-based projection of the load impacts of our portfolio, of our RAP level portfolio, our MAP level portfolio, our other portfolios, and it reduces our load, which is also an hourly forecast. And so when Mr. Michaels and then the IRP team are calculating kind of the net present value of revenue requirement in the integrated resource plan, he's going to price, whether we're short or long capacity at our kind of forecasted or projected capacity prices in MISO. So those are the charts that appear throughout Mr. Lubert's testimony. And so the short or long position based off of the peak hour that includes shaped peak impacts of our portfolios, it's going to essentially price that at the capacity price that's in whatever IRP scenario that we're running there. And so really, when you're looking at the most robust and detailed planning, assessment of how these are going to impact our seasonal peak loads and how the MISO seasonal peaks influence what portfolio is going to be most cost effective, it's going to be from evaluating that net present value of revenue requirement that included all of those assumptions in it. Projections with the best available data, that we have. So it's going to tie straight through to the process that we're going to use when we actually get a capacity obligation in MISO, because that's going to be based off of our peak forecast. So the planning version of that is the IRP, where we have a peak forecast that's based off of hourly shapes applied to the measures in our portfolio as load reduction resources, so to speak. And hopefully that's enough detail to answer your question.
Well, I guess it was a lot of detail, and I appreciate that, Mr. Wills, but I guess I didn't hear what hours, though.
So if you recall, at the beginning of that, I said the way that we get the hours are our peak hours for that season, because the way that's what hours, whatever hour in our forecast the peak hour is going to be the hour that is being assessed kind of through that, because we know when we get to operations, our peak forecast is going to be the basis of that. It's going to have a coincidence factor applied to it before it gets offered into the MISO Module E. But the hour is our system peak hour of that season is what it's being planned to.
All right, well, I guess for the commission's knowledge, what is the peak hour during spring for Ameren?
It's dependent on weather.
And then I guess also when you're talking about the assumptions and forecasting, are you aware what will the demand reduction capability of the demand response programs be for the spring MISO PRA hours in 2025?
I saw some numbers in Mr. Michael's spreadsheet that he was looking at when we were preparing, and I know it was around 170 megawatts was expected. I don't want to say that that's precisely 170, but that was what when we were discussing this earlier this week, I saw that spreadsheet, and my recollection is that it was around 170 megawatts.
Okay, and are you also able to recall what that would be in 2026?
I don't know, have a year by year on that. I think they were, for demand response, they were relatively similar year to year. I think, the programs are pretty well subscribed at this point, so I don't know if there may have been some growth due to additional participation, but I think it was relatively flat across the 3 years.
Okay, so that would also apply to 2027, that 170, you think?
It's my best estimate.
And can you answer that same question for the fall?
It was very similar. It was a very similar number. So if you think about the fall and spring peaks, I think this came up the other day, but the fall season in MISO is September, October, November. The spring season is March, April, May. In general, those peaks happen in September and May on hot weather days that kind of the measure mix that will produce peak savings is the very same measure mix that's going to produce peak savings in the summer. So to the extent that you are designing your programs for peak impact in the summer, they're going to have similar efficacy in the spring and fall.
And then finally, I think you see this one coming for the winter.
And I'm sorry, for the winter, what's the
Yes, what will the demand reduction capability of the demand response programs be for winter MISO PRA hours?
I think of the existing resource right now, it's quite small. I think it was 6 to 10 megawatts, something like that. I will tell you that that's based off of present, enrollment, and as either Mr. Lozano or Vi indicated, we're in the process of testing our winter capability with some of our programs and expanding the thermostat capability to the winter. I know there was a test event held in winter of 2023 that, again, I'm going to use a round number because I don't have it memorized out to the end, but it was somewhere around in between, I think, 60 or 70 megawatts of capability that we were able to test and demonstrate. That hasn't been and can't be bid into the MISO auction unless and until we have a program year that spans the full MISO planning year. But I think we're fully anticipating doing that and prepared to do that.
And And just a little clarification on that 170 number, Mr. Wills. Is that for a warm May or a cold March?
I didn't see that. I feel pretty comfortable speculating that it was May, or I'm even speculating, but I have got experience in doing the forecasts historically, so I maybe informed speculation that it's probably May.
Thank you for your time, Mr. Wills. No further questions, Judge.
Mr. Pringle, thank you. Any cross from public counsel?
No, thank you.
Any bench questions? Chair Hahn, when you're ready.
Good afternoon, Mr. Wills.
Good afternoon.
I have spent some time looking over the EM&V for 2023 and also the Appendix A with the megawatt savings and the TRC values. Some of the programs don't perform really compared to others, so some of them don't really achieve any significant megawatt savings. Some of them don't pass the TRC. And thinking about Ameren's MEEIA portfolio, I'm just going to give an example. The energy efficiency kits, for example. They seem to probably have fairly high overhead, fairly low savings on megawatt or dollars. So help me understand why that's included as part of the portfolio.
Yeah, I'll do my best, and Mr. Vai may have had more to offer on this, but I think as I understand it, the kind of the design of the portfolio is a couple of things. Is a part of driving participation in programs is creating awareness, and I think those kits are maybe used as an entryway to drive awareness of programs that might drive participation in other things. Again, I'm not super well versed in the very details of that, but if I think that's at least a part of that situation there.
One program that performs not well in either the EM&V or according to Appendix A is the PAYS program. So I'm just trying to go program by program. What programs, if we're going to continue with MEEIA programs, produce the most savings at the least cost? And so some of the programs that are included don't do that, and PAYS in particular doesn't seem to perform.
So and again, Mr. Vai or Lozano may have more detail on this, but my understanding. So, are you familiar with the PAYS concept model? My understanding is that the barrier to participation there has been the fact that, and I actually participated in the PAYS, so I've experienced this. So when you go in and do a home energy audit for folks, and I think it's very comprehensive and can get very good and deep savings. But there also then becomes, the pay-as-you-save model only allows you to pay up to an amount that when it's recovered on the bill, it will be less than the savings that are projected for the efficiency upgrade. And so any additional measure cost is an upfront payment that the participant has to make. I paid an $800 check to get my efficiency upgrades, and there was an incentive that was paid to cover the other part of it. I'm able to make an $800 payment, when that comes up. I think a lot of my understanding is a lot of the problems driving adoption, which would grow the scale of that and might improve the cost effectiveness, is that upfront payment element of it. So, I think that's some of the genesis of that as I understand it. So, does that answer your question?
Yeah, I think so. Earlier, I think maybe Mr. Lozano was asked if we were reducing, the commission decided to just reduce the budget. Would Ameren just reduce the budget for every program equally, or would you use some program measures to figure out which ones to implement? If the commission were to reduce the overall budget, how would Ameren go about handling that?
Yeah, I mean, I think we can give you a high level. I mean, we'd have to go back and, you know, do some, you know, probably analysis and comparisons and trade-offs. But I mean, I think, like, you know, to the point Mr. Lozano made, I think we would look at the cost effectiveness of the programs, and certainly try to, you know, retain the most budget and the most highly cost-effective areas. You know, there may be strategic considerations about how one program impacts another. You know, I'm not suggesting that kits would make but in my example where it was used to drive program participation in other places because it created awareness, maybe there would be a strategic consideration like that. I don't expect, I mean, at least based off what I know about it, I don't expect that kids probably would be the one that would do that. But that's just an example of another type of consideration we might have. But I think it would have to be just a careful redesign of, okay, look at what are the attributes we're looking for. We need to get enough demand savings, we need to get enough energy savings, and we need this to be as cost effective as possible. And I think people could systematically go through the programs and understand the kind of interrelationship with those programs and make the best decisions for that. I think we could certainly do that.
Okay. It seems like that could be, I mean, if we're trying to keep energy efficiency as part of if that's the goal, to keep as part of the portfolio, it seems like maybe looking at how the programs perform, maybe a viable path forward. I don't know. But
Yeah, and I mean,
just thinking through it.
And I think that's a great thing to be thinking about. And you know, honestly, the thing I don't know mostly is about procedurally how we get from here to there. But I absolutely think the company can, you know, if you got guidance about, you know, what level you're considering, I think the group can go back and think about how it would construct that, how it works out procedurally. I don't know if the lawyers figure out how that would happen, but
I have to ask a lot of procedural questions and get educated quite frequently.
Yeah.
You know, there's just, everyone can use that even evidence that's in the docket on what performs and doesn't, and go through and figure out what performs and doesn't. And
yeah, I think there would be a path to getting there. We would just have to navigate it.
thank you.
Yeah.
Chair Hahn, thank you. Any further bench questions? Hearing none, I think I have maybe a couple. I think these are similar to Chair Hahn's questions, but not quite the same. Could any of these programs be offered at a lower cost if the MEEIA cycle increased from 3 years to, say, 5 years?
Again, this is probably a Mr. Lozano or Mr. Vi question better, but my understanding is that generally, yes, over a longer term, they may be able to get, lower cost. I'm a little bit out of my league, but I think that a longer term generally can probably produce lower, some lower administrative costs for administering that program. Don't hold me to it, but that's my expectation.
If the company were charged with decreasing its administrative costs to around 25%, what would the impact be to specific programs or measures?
Boy, that one really might actually be fully out of my depth.
I understand. All right. Mr. Wills, thank you. Let me see if we have any recross based on bench questions, any cross from Renew Missouri.
No, thank you, Judge.
Thank you. From NRDC?
No, thank you, Judge.
Thank you. From staff?
One moment, Judge. No questions, Judge. Thank you.
Thank you. Any recross from Public Counsel?
No, thank you.
Redirect?
A few, thank you. I want to take you back to when you were answering Chair Hahn's question about if budgets were reduced, if Ameren could evaluate the programs to keep in the portfolio. And I want to ask you in particularly, when you look at a program's performance, can you evaluate that program's performance on a given year or a snapshot, or is there a certain time period that you look at that program's performance to evaluate its effectiveness over time.
I mean, I think both are probably important. You know, we certainly will have an evaluation annually of that, but I think also looking at the trends it would be important as well. So, I mean, I don't think that you would probably exclusively look at either 1 year or a long time horizon. You probably want information about both.
Nothing further, thank you.
All right, thank you. Mr. Wills, thank you very much. You may step down.
Thank you.
This looks to be a good time to take a break. Since we started before 1, I'd like to take a couple of breaks this afternoon and then go till roughly 5 o'clock, depending on how the witness flow goes. So I show the time to be not quite 2 o'clock, so let's take a break until about 2:15, and then I believe Mr. Brueggemann will be the next witness from Ameren. Anything from council or from the bench before we take a break?
Your Honor, I just want to remind you the next 2 Ameren witnesses have not been sworn in.
Thank you for the reminder. I appreciate that, Ms. Moore. All right, we will be on break until 2:15. Thank you. We are off the record. Brian, are you ready? All right, good afternoon. We are back on the record. I believe Ameren, Missouri witness Brueggemann is next to take the stand. Anything further from the bench or from counsel before he testifies? All right, Mr. Brueggemann, come forward and be sworn, please. If you'll raise your right hand to be sworn, do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you very much. You may have a seat. And Ameren, when you're ready.
Thank you, Your Honor. Good afternoon, Mr. Brueggemann. Could you please state your name and spell it for the court reporter?
Yes, it's Jeff Brueggemann, Jeffbrueggemann.
And Mr. Brueggemann, did you prepare direct testimony filed in this proceeding?
Yes, I did.
And I think we have identified that as Ameren Exhibit 112.
That's correct.
If I were, do you have any corrections or changes to those to your direct testimony?
No, I do not.
If I were to ask you the same questions that are contained in your testimony today, would those questions still be the same or similar?
Yes, they'd be the same.
And are your responses to those questions contained in your direct testimony true and accurate to the best of your knowledge?
Yes, they are.
With that, Your Honor, I move to admit Ameren Exhibit 112 and tender Mr. Brueggemann for direct testimony. For cross-examination.
Ms. Moore, thank you. I'm sorry. 112 is
The direct testimony.
direct.
Yes.
Thank you. Any objections? Hearing none, exhibit number 112 is admitted into evidence. Cross-examination, Renew Missouri.
No, thank you, Judge.
NRDC,
No, thank you, Judge.
any cross from staff?
Yes, Judge, thank you. Good afternoon, Mr. Brueggemann.
Good afternoon.
And were you here for the testimonies of Mr. Vai and Mr. Lozano?
I was.
Yes, did you hear them defer a few questions to you?
Yep. Yes, I did.
All right, Mr. Brueggemann. My questions have to do with the TRC. Does the TRC consider program costs?
In the context of program cost, if you mean administrative cost for the programs, yes.
And to be clear, that's just the admin costs of the programs.
I'm not saying it only includes that. I'm saying it includes program cost is kind of a general term, so you can
Then-
define that different ways.
Does the TRC consider incentive costs?
The TRC includes the equivalent of incentive costs because it includes the incremental measure cost of participants. For example, if you're being incented to put in a new air conditioner and the difference between the base unit and the efficient unit is $500, that $500 is called an incremental measure cost from going from base to efficient. That is included in the TRC. Our incentives are a component of that, so we're giving an incentive as a portion of that $500 to pay down that incremental cost. So yes, depends on how you look at it in terms, but it's included.
Does that include the whole range of incentives?
Does that include Can you please clarify that?
I guess, does TRC take into account both the high and the low and the high end of the incentives?
There's only one incentive. And this is, the discussion around this is pretty detailed in Mr. Will's testimony. So I recommend that you read that in detail because there is a lot of discussion around what is included in the TRC and what shouldn't be included and how it is calculated.
Well, thank you for that, Mr. Brueggemann. And then finally, does the TRC consider EO cost?
The portfolio, yes, it includes the EO costs.
And sorry, I have one more for you. Does it include TD cost?
TD is not technically a cost in that context, no. It's kind of a transfer cost, so no, it is not included.
Thank you, sir. That's all the questions I have at this time.
Mr. Pringle, thank you. Any cross from public counsel?
No, thank you.
Any bench questions? All right. Redirect?
All right, Mr. Briggerman, you weren't here earlier this week and didn't hear all of the context behind this. Does the TRC include, when you talk about incremental cost, that level of incremental cost, does it matter if the incentive is changed within the plan? How would you account for that? For example, I think we have in our Appendix D a ranges of incentives. And I think the question is, how is that accounted for?
So there's multiple times that there's a TRC calculated. There's a TRC calculated for the plan, and there's also TRCs calculated for evaluated results.
Okay,
So the
I think we want to focus on how you did it for the plan.
So the TRC includes one level of incentives, what is built into the plan. The range, there's a high and a low range, and that incentive has to fall somewhere in between that range.
All right, so if the incentive is increased, would the TRC number change?
Not to the extent that it would. Let me think about that for a second. Not to the extent that it would exceed the incremental cost, because typically, in most cases, our incentives would be something lower than the incremental cost. So if you go from 50, let's say the incremental cost was $500 and we gave a $250 rebate. That $500 is included in the TRC cost as an incremental measure cost. If you raise that incentive to $300, the $500 still covers that $300 of incremental measure cost.
Great,
So
I'm sorry.
anything up to that $500, yes, it is going to cover that range.
Great, thank you. I have no further questions, Your Honor.
All right, Ms. Moore, thank you. Mr. Bergman, thank you very much. You may step down. And I believe Mr. Huber is the next witness. And I understood we were going to take Ms. Sherwood after Mr. Huber. Is that correct?
I believe that is correct, Your Honor.
All right, very good. Thank you.
And Mr. Huber is appearing remotely.
Oh, very good. Mr. Huber, if you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Very good. Thank you. Ameren, Missouri.
Yes, good afternoon, Mr. Huber. How are you?
Good, and you?
Good, thank you. Could you please state your name for the record and spell it for the court reporter?
Sure. My name is Jeffrey Huber. That's Jeffrey. Huber, Hub as in boy, ER.
Yes, and by whom are you employed in what capacity?
I'm a principal at GDS Associates, an engineering consulting firm.
And in this proceeding, did you file direct testimony which has been identified as Ameren Exhibit 113?
Yes,
Do you have any changes or corrections to that testimony?
I do not.
If I were to ask you the questions that are contained in that testimony today, would your answers be the same?
They would.
And are the answers contained in that direct testimony accurate and true to the best of your knowledge?
They are.
Your Honor, I move Ameren Exhibit 113 and tender Mr. Huber for direct testimony, for cross-examination.
And Ms. Moore, I'm sorry, that's Mr. Huber's direct testimony, is that correct?
Yes, he only had direct testimony. That is correct.
Exhibit number 113 has been offered. Any objections? Hearing none, Exhibit 113 is admitted into evidence. And any cross-examination from Renew Missouri?
No, thank you, Judge.
Thank you. Any cross from NRDC?
No, thank you, Judge.
Cross from staff?
No, thank you, Judge.
Public counsel?
No, thank you.
Any bench questions? All right, thank you. Mr. Huber, thank you very much.
Thank you.
And I believe we're ready for Ms. Sherwood, is that correct? Ms. Rubenstein,
Yes.
I believe, did you want to go ahead and direct for your witness and get her ready for cross?
Sounds great. She will need to be sworn in and is also appearing remotely.
Very good. Ms. Sherwood, if you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you very much. Ms. Rubenstein, when you're ready.
Good afternoon, Ms. Sherwood. Could you please state your name for the record and spell it for the court reporter?
Good afternoon. Yes, my name is Stacy Sherwood. It is spelled Stacy, S-T-A-C-Y, Sherwood, S-H-E-R-W-O-O-D.
And where are you currently employed?
I'm employed with Energy Futures Group, which is a consulting firm that specializes in energy efficiency and integrated resource planning.
What is your business title at Energy Futures Group?
I'm a principal at Energy Futures Group.
Did you prepare and cause to be prepared in this case your direct testimony?
Yes.
And is the resume that is attached as exhibit, I believe, NRD1 to your direct testimony a true and correct copy of your resume?
Yes, it is.
Do you have any changes or corrections to your pre-filed direct testimony at this time?
No, I do not.
If I asked you the questions in your direct testimony at this time, would your answers be the same?
Yes, they would be.
And is the information in those answers true and correct to the best of your knowledge?
Yes, they are.
Your Honor, I move for the admission of Ms. Sherwood's direct testimony in this case. I believe it would be marked Exhibit 450.
Ms. Rubenstein, thank you. Exhibit 450 has been offered. Any objections? Hearing none, Exhibit 450 is admitted into evidence.
Great. And Ms. Sherwood, did you prepare and cause to be prepared in this case your rebuttal testimony?
Yes, I did.
Do you have any changes or corrections to your pre-filed rebuttal testimony at this time?
No, I do not.
If I asked you the questions in your rebuttal testimony at this time, would your answers be the same?
Yes, they would be.
And is the information in those answers true and correct to the best of your knowledge?
Yes.
Your Honor, I move for the admission of Ms. Sherwood's rebuttal testimony in this case to be marked Exhibit 451.
Great, thank you. Exhibit 451 has been offered. Any objections? Hearing none, Exhibit 451 is admitted into evidence.
Thank you, and I tender the witness for cross-examination.
All right, Ms. Rubenstein, thank you. Any cross-examination of Ameren, Missouri?
Yes, thank you, Your Honor. I just have a few quick questions. Ms. Sherwood, in your rebuttal testimony on page 13, you talk about the Weather Assistance Program. I'm just wondering if you think that there is sufficient funding to adequately address the needs of Ameren service territory for that program if the MEEIA programs were not approved by the commission.
No, as stated in my rebuttal testimony, I don't believe that there is sufficient funding to address the need that's within the state. When I had reviewed those who would qualify for weatherization assistance, so those below 200% federal poverty level, you're talking over 300,000 homes that would qualify in the entire state of Missouri, so beyond just that of Ameren's. And on an annual basis, the WAP program is funded to address about 1,200 homes statewide. So there's a significant gap in the level of funding that's available and the need that's even just in Ameren's service territory.
Thank you. Your Honor, I have no further questions.
Ms. Moore, thank you. Any cross from NRDC?
This is our witness, Judge.
I'm so sorry. You're right, I apologize. Any cross from staff?
Not this time, Judge. Thank you.
Any cross from public counsel?
Yes, just 1 minute, Judge. Good afternoon, Ms. Sherwood.
Good afternoon.
Do you by chance have a copy of Dr. Mark's SIR rebuttal testimony?
I do not have that on me.
Okay, is a way for you to get a copy of that?
Let me, I'm sorry, did you say rebuttal or SIR rebuttal?
Sorry, SIR rebuttal.
Thank you.
I can get a,
Do you know what pages? I have some pieces of that printed out, actually.
in particular, page 26, table 4.
I actually do have that.
Okay, are you looking at that?
Yes, I am.
Okay. You would agree with me that the LIWAP program caps administrative costs at no more than 15%, correct?
I think that's dependent on the state, so I will be in agreement, subject to check.
Okay. And you would agree with me that the historical administrative cost for Ameren, Missouri's similar program is approximately 48%. Is that correct?
Can you clarify when you say admin, does that include marketing costs and EMMB?
No.
And is that just of the program itself? I apologize. I just want to make sure before I agree to this, I agree to the correct 48%.
Yes, to this program.
Then yes.
And you would agree with me that there's no earnings opportunity associated with the LIWAP program, correct?
That is correct.
But you would agree with me that there is an earnings opportunity portion associated with Ameren, Missouri's proposed program, correct?
Correct.
And at maximum, that's approximately $11.4 million, correct?
Subject to check, yes.
Nothing further. Thank you, Judge.
Ms. Van Gerpen, thank you. Did I overlook anyone who wanted cross? I may have misread this list. Renew Missouri, perhaps. I don't.
No, thank you, Judge. Thanks for checking.
Very good, thank you. Any bench questions for this witness?
Just one, Judge.
Commissioner Mitchell, when you're ready, sir.
Yeah, I thank you for your testimony, and you mentioned a significant gap in the weatherization funding needs, and I believe you. The question I have is how far, and you don't have to be exact with this answer, but how far would the weatherization component of this program go to close that gap?
I don't know if I can quantify that off the top of my head. I would say, I've run these numbers though in other states that I've worked, and the amount of money is astronomical, especially if you're including barriered homes. And so while I don't think it would significantly close the gap, I think it's making a step towards closing that gap.
Thank you. Thank you.
Commissioner Mitchell, thank you. Any further bench questions? Hearing none. Any recross based on bench questions, Ameren, Missouri?
Thank you. No, thank you, Your Honor.
Renew, Missouri?
No, thank you, Your Honor.
Thank you. On behalf of staff?
Yes, Judge. Good afternoon.
Good afternoon.
Just a follow-up on Commissioner Mitchell's question. Can the company only offer a weatherization program through MEEIA?
No, it would not be limited to only MEEIA. There are other opportunities that could be offered and that I've seen in other states.
Thank you, ma'am. No further questions, Judge.
Thank you. Any cross from public counsel?
No, thank you.
Any redirect?
No, thank you, Judge.
All right, thank you. Ms. Sherwood, thank you very much.
Thank you.
I believe we are on to staff witnesses now, starting with Jordan Hull.
That's correct, Judge. And for Mr. Hall, this will be his first time taking the stand, so we'll be going through direct.
Very good. And Mr. Hull, if you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? I do. Thank you very much, sir. You may have a seat. Mr. Pringle, when you're ready, sir.
Thank you, Judge. Good afternoon, Mr. Hall. Please state and spell your name for the record.
My name is Jordan Hall, Jordan, last name Hull, Hull.
Thank you, Mr. Hall. And by whom are you employed and in what capacity?
The Missouri Public Service Commission as an associate engineer in the Energy Resources Division.
And are you the same Jordan Hall who caused to prepare direct testimony in this matter, pre-marked Staff Exhibit 219?
Yes.
And at this time, do you have any corrections to make to Exhibit
I do not.
219? If I were to ask you the same questions within Exhibit 219, would your answers be the same or substantially similar?
Yes.
And is the information contained in Exhibit 219 true and correct to the best of your belief and knowledge?
Yes.
And did you also cause to prepare in this proceedings rebuttal testimony?
No.
No, that's what I thought. Just wanted to double check. Well, at this time, staff moves to enter Exhibit 219 on the record.
And so this is Mr. Hull's direct, is that correct?
That's correct, Judge.
Any objections to Exhibit number 219? Hearing none, Exhibit 219 is admitted into evidence.
Thank you, Judge. At this time, staff tenders Mr. Hall for cross-examination.
Mr. Pringle, thank you. Any cross from public counsel?
No, thank you.
Renew, Missouri?
No, thank you, thank you.
Thank you. NRDC?
No, thank you, Judge.
Ameren, Missouri?
No, thank you.
Any bench questions? Right, hearing none. Mr. Hull, thank you very much.
Thank you.
Ms. Stevers, the next witness, is that correct?
Yes, Judge. And also, Ms. Stever, this will be her first time, so we'll be going through direct.
Thank you. All right, if you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you very much. You may have a seat. Mr. Pringle, when you're ready.
Good afternoon.
Good afternoon.
And please state and spell your name for the record.
My name is Marina Stever, Marina-Stever, as in Valentine, E-R.
Thank you, Ms. Stever. And by whom are you employed and in what capacity?
I am employed by the Missouri Public Service Commission as a senior research data analyst for the Tariff Rate Design Department.
Thank you, Ms. Stever. And are you the same Marina Stever who caused to prepare in these proceedings direct and rebuttal testimony that have been pre-marked as Staff Exhibits 220 and 221?
Yes.
Is the do you have any corrections to make to Exhibit 220 or 221 at this time?
Yes. So to my direct testimony, on page 2, footnote 1, that should read, ER-2024-0187. On my rebuttal testimony, page 2, footnote 2, that should read ER-2024-0187. And then I do have a correction to schedule MSD2 for the MEEIA Cycle 3 gross kilowatt hours avoided.
And what is that correction?
That number previously read 1,348,564,638 kilowatt hours avoided, and it should read 1,537,350,788 gross kilowatt hours avoided.
Thank you, ma'am. And do you have any further additions or corrections to make at this time?
No.
And is the information contained within Exhibits 220 and 221 true and correct to the best of your belief and knowledge?
Yes.
If I were to ask you the same questions within Exhibit 220 and 221, would your answers be the same or substantially similar?
Yes.
Thank you, Ms. Stever. At this time, Judge, staff moves to enter Exhibits 220 and 221 onto the record.
Exhibits 220 and 221 have been offered. Any objections? Hearing none, Exhibits 220 and 221 are admitted into evidence.
Thank you, Judge. At this time, staff tenders Ms. Stever for cross-examination.
Mr. Pringle, thank you. Any cross-examination from public counsel?
No, thank you.
Any cross from Renew Missouri?
No, thank you, Judge.
NRDC?
No, thank you, Judge.
Ameren, Missouri?
No, thank you, Your Honor.
Any bench questions? All right, hearing none. Ms. Stever, thank you very much.
Thank you.
I believe Ms. Eichholz is the next witness. I hope I'm pronouncing that correctly.
Yes, that's correct, Judge.
And have you been sworn, Ms. Eichholz? All right, if you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you very much. You may have a seat. Mr. Pringle, when you're ready.
Thank you, Judge. Good afternoon, Ms. Eichholz.
Good afternoon.
Please state and spell your name for the record.
Amy Eichholz, AMYEICHHOLZ.
Thank you, Ms. Eichholz. And by whom are you employed and in what capacity?
The Missouri Public Service Commission. I am a research data analyst.
And are you the same, Ms. Eichholz, who caused repair in these proceedings, direct and rebuttal testimony that have been pre-marked as staff exhibits 222 and 223?
I am.
Do you have any corrections or additions to make to exhibits 222 and 223 at this time?
I do not.
If I were to ask you the same questions within exhibits 222 and 223, would your answers be the same or substantially similar?
Yes, they would.
And is the information included in exhibits 222 and 223 true and correct to the best of your belief and knowledge?
Yes.
Thank you, ma'am. At this time, Judge, staff moves to enter exhibits 222 and 223 on the record, the direct and rebuttal testimony of Ms. Amy Eichholz.
All right, exhibits 222 and 223 have been offered. Any objections? Hearing none, exhibits 222 and 223 are admitted into evidence.
Thank you, Judge. At this time, staff tenders Ms. Eichholz for cross-examination.
All right, any cross-examination of public counsel?
No, thank you.
Any cross from Renew Missouri?
No, thank you.
NRDC?
No, thank you.
Ameren, Missouri?
I just have a couple quick questions regarding the tariff recommendations. In making those recommendations, is there any other jurisdiction that puts that amount of detail into the energy efficiency tariffs that you're aware of? Not that I'm aware of. All right, thank you. And isn't it also true, or you would agree with me, that the rider EEIC appears as a line item on a customer's bill? Yes. And so if a customer had any questions, they could either call the company or I think the PSC number is on there too regarding the rider EEIC charge and what goes into that. Is that correct?
I'm not real familiar with the rider EIC. I mean, that would be something you may want to refer to Mark Kiesling.
Okay, thank you. No further questions, Your Honor.
Ms. Moore, thank you. Any bench questions? Chair Hahn.
Good afternoon, Ms. Eichels.
Good afternoon.
Staff counsel earlier mentioned that you had some concerns with the current income eligible programs, specifically the low income programs. Can you talk about that?
Yes. Outside of MEEIA, there's several programs available for the low income, as in the Keeping Current, the Critical Needs Program, the Rehousing and Weatherization. So, I mean, I'm not saying MEEIA programs aren't a good thing, but in the IRA, regardless of the MEEIA program, there's several programs available for the low income and multifamily income.
And do those programs provide similar opportunities for energy efficiency as the MEEIA programs?
They do, if not more.
In your testimony, you also write about the eligibility for the low-income programs and how you weren't sure if, because of the eligibility guidelines in the MEEIA programs, if it was actually reaching the low income, because it was set at 135 to 200% of federal poverty level. How does that federal poverty level compare to other low-income programs, or do you know?
I'm not exactly sure.
Okay. Okay. Thank you.
Thank you.
All right, Chair Hahn, thank you. Any further bench questions? We're hearing none. Any recross based on these bench questions? Public counsel.
No, thank you.
Renew Missouri.
No, thank you.
NRDC.
No, thank you.
Ameren, Missouri.
No, Your Honor, thank you.
Any redirect?
One moment, Judge. Briefly, Judge. Ms. Eichels, Ameren questioned you about other jurisdictions providing this much detail on energy efficiency tariffs. And you answered that you were unaware. Just to clarify that answer, you are not aware if other jurisdictions do include that much detail or do not?
I'm unclear of the question, sorry.
When Ameren asked you about the level of detail to be included in the energy efficiency tariffs, they asked about if there were other jurisdictions that required that much detail. Your answer was you were not to your knowledge. Just to clarify, that answer covers not just whether the detail is required, but let me go ahead and rephrase that for you. To your knowledge, you are not aware if other jurisdictions require that much detail or not.
I guess I should rephrase that and say as far as like the applications and everything that are submitted do.
Just one moment, Ms. Eichels. Have you reviewed the tariff sheets in other jurisdictions for energy efficiency?
Yes, I have.
Was your review limited to income eligible tariffs?
Yes.
Do you believe that more detail in a tariff is better?
I do.
Thank you, Ms. Eichels. No further questions, Judge.
Right. Mr. Pringle, thank you. Ms. Eichels, thank you very much. I believe the next witness will be Mr. Kiesling. Sorry, Ms. Nichols, you can step down. I'm sorry. Thank you. And Mr. Kiesling, you're still under oath. Anything before he stands across, Mr. Pringle?
Yes, Judge, this is Mr. Kiesling's last time on the stand, so at this time, we would move to enter Exhibits 212, 213, and 214. 212 is the direct testimony of Mr. Kiesling, 213 is the corrected rebuttal testimony of Mr. Kiesling, and 214 is the surrebuttal testimony of Mr. Kiesling.
Exhibits 212, 213, and 214 have been offered. Any objections? Hearing none, Exhibits 212, 213, and 214 are admitted into evidence.
Thank you, Judge. At this time, staff tenders Mr. Kiesling for cross-examination.
Mr. Pringle, thank you. Any cross, Public Counsel?
No, thank you.
Any cross from Renew Missouri?
No, thank you, Judge.
NRDC?
No, thank you.
Ameren, Missouri?
No questions, thank you.
All right, thank you. Any bench questions? All right, hearing none. Mr. Kiesling, thank you very much. I believe Mr. Lubert is next to take the stand. And you are still under oath, Mr. Lubert. Mr. Pringle, anything before he takes cross-examination?
Yes, Judge, this will be Mr. Lubert's last time on the stand for these proceedings, so we would move to enter what has been pre-marked as Exhibit 209, which is the public and confidential direct testimony of Jay Lubert, Exhibit 210, which is the public and confidential rebuttal testimony of Jay Lubert, and Exhibit 211, which is the surrebuttal testimony of Jay Lubert.
All right, I have Exhibits 209, 209C, 210, 210C, and 211 that have been offered. Any objections? Hearing none, Exhibits 209, 209C, 210, 210C, and 211 are admitted into evidence.
Thank you, Judge. At this time, staff tenders Mr. Lubert for cross-examination.
Any cross from Public Counsel?
No, thank you.
Cross from Renew Missouri?
No, thank you.
NRDC?
No, thank you.
Ameren, Missouri?
None, thank you.
Any bench questions?
This one, Judge.
Commissioner Mitchell, when you're ready, sir.
I'm just following kind of lead from counsel again. Can you speak to any concern on the thermostat program?
I think I caught you, but I just want to make sure you asked if I can speak to any concerns on the thermostat program.
Correct.
I can. I guess I should caveat that with there may be others that can provide more detail, just depending on the specific question. But one of the concerns that I know that I have and that I'm aware of is, and we've talked about this a few times during this hearing, about the timing of demand reductions and the timing of that those reductions as you're planning to move forward. As far as I'm aware, the thermostat programs to date for Ameren have been limited to summer events. So looking at potentially reducing demand during a summer peak. What we're looking at currently with the MISO Zone 5 PRA results and just kind of looking at that seasonal construct going forward is an increased importance on what peaks look like in each of those 4 seasons. The thermostat program, you know, there may be some potential there for winter, what that potential for, but that potential is obviously going to look different than it would in the summer, and it would also require kind of the ability to actually call events during that time period. I think when you're looking at spring and fall, the weather that occurs during those time periods is going to affect what those hours are, and so that capability is also going to be fairly different than what you're looking at for summer potential summer reductions. I know that one of the things that Mr. Mark brought up in his testimony, and I can't recall if staff mentioned the thermostat specifically in this manner, but one of the things that Mr. Mark brought up, or Dr. Mark, I'm sorry, was that, and with the amount of kind of incentives that have been paid out for the existing thermostats, that it might make sense to kind of continue that residential demand response with those existing assets in place already, even if the current application wasn't approved. And I do think that there is some validity to looking at some of that sunk cost for those assets that are unlikely to drive the demand reductions that you would have expected, without kind of incentivizing those ratepayers to go ahead and participate in demand response on an ongoing basis, but also the ability to kind of save, not have additional program expenditure to continue to kind of build that until it makes more sense. I think, you know, this section of the hearing is talking about programs, and I'd be remiss to not bring up that it's really so important for us to be designing these programs with a specific end goal in mind. And I know that we've heard some Ameren witnesses talk about, you know, their ability and flexibility to kind of pivot how some of these programs will work. And there was some mention of looking at demand response in seasons other than summer. As we went through kind of the extension, this last cycle extension, you know, I'll point out that part of that stipulation was for the company to be required to look at what their capabilities for demand response would be in seasons other than summer, because we hadn't seen that. And we see that as an important aspect for planning going forward.
Thank you.
All right, Commissioner Mitchell, thank you. Any further bench questions? I think I have just a few, Mr. Rubert, and these are kind of along the same lines I believe I asked Mr. Wills earlier. Could any of the programs be offered at a lower cost if the MEEIA cycle increased to 5 years or so?
I hate to give answers that are so heavily caveated, but unfortunately I'll have to this time. I think the answer is programs could be offered at a lower cost. Whether or not pushing a program out an additional 2 years would do so is a possibility, but I think what kind of the most important factor that kind of has to be considered is what you're achieving in doing so. And so, you know, even if costs are comparable if you're getting diminishing returns over that time period, it may not make sense to do so. So again, and I know I've mentioned this before, but the details around that are so important. And I think what we're seeing, well, if you don't mind, can I take a step back and just kind of explain what we've seen thus far with MEEIA have been 3-year cycles. And in the third cycle, there have been these 1-year extension, kind of short-term, maybe a good way to explain them are kind of bridge years, right? But once that cycle is approved, the commission and the ratepayers are locked into what's been approved. And when the company seeks near maximum flexibility, but ratepayers and the commission and other stakeholders have very little, it can become problematic. When we're talking about long-term planning, I think it's important to consider how rapidly things are changing within this electric industry right now and over the last decade, and what is expected to happen over the next decade. So extending or locking in not only ratepayers but the commission to what's been approved for 5+ years can kind of bring its own challenges and its own concerns that I know we haven't kind of fully fleshed out, at least within this docket.
Can you think of other changes that could be made to this proposal that would decrease the administrative or program costs?
I can. And I will. I'm going to direct you, and I think this actually, it goes back to something that Chair Hahn was asking about trying to figure out kind of which programs are kind of optimal or the best programs. And I want to direct you to a schedule that was attached to Mr. Fortson's surrebuttal. And I think my attorney has some if you want to hand those out.
Yes, Judge, I do have copies of the schedule if the bench would like a copy.
It'll be fine, thank you.
Yes. And for everyone's,
Oh, I see the testimony that corresponds to this too.
yes, this is from the surrebuttal testimony of Brad Fortson, which has been entered onto the record as Exhibit 208.
All right, thank you. Thank you.
So, just to give some context, we've been talking about kind of the planning and trying to figure out which programs would be best suited on a going forward basis. And the context here is Mr. Fortson attached this to his surrebuttal testimony, and it was also attached in an email to Ameren a couple months at least. I think he describes the email and kind of Ameren's response at that time in his testimony, but it was a couple months before their revised application. And this is some of the information that we were trying to walk through with the company so that we could understand exactly this question, right? Where are the programs that are going to drive kind of the most demand reductions in time periods that matter the most. And so if you let me, I'll kind of walk through kind of how this was set up and what this is asking for. And I think it really feeds into what the chair was asking about, which is trying to identify kind of those best performers. So this first sheet or first tab is asking for Ameren to identify target hours. And so it looks like it is by year, and it's asking for winter, spring, summer, and fall, the anticipated MISO capacity hours, the anticipated Zone 5 net peak load hours, and Ameren's anticipated net peak load hours. If you turn to the next page, this would be the next tab. It's titled Identifying Target End Uses. And if you see at the top, and I think it's in orange text or yellow text, it says, then identify the end uses with the most energy consumption that may result in requiring supply side expenditure. And so it breaks this down by year, month, day, and hour. And then it has a listing of end use categories. So for example, residential heating, residential cooling, residential cooking, and there, you know, it breaks it down kind of by end use type, but also class type. And what this is trying to identify are what are those measures that are driving some of that that usage in those peak hours that we just talked about. The next tab is it talks about identifying avoidable costs associated with each of those end use. And so kind of the intention of this, I know that the majority of the sheets are left blank, but that was because we were providing it to Ameren and asking for them to kind of fill it out and provide summary tables from there. But if you'll see, it breaks this down by those kind of those end use categories and trying to identify the annual KWH avoided, what the average LMP of that that avoided energy would be by year, and then the expected demand reductions winter, spring, summer, and fall, and that would also need to be by year. Like we were talking about, the kind of that timing and the longevity and the magnitude are of utmost importance as we're looking toward planning going forward. And so this was trying to kind of identify is what are those measures? What are those end uses that if we can reduce some of that attribution to peak, there's a possibility that we can avoid some of that investment. If you look at the next tab, it's got a summary, and then that would break it down into kind of residential, commercial, and industrial costs and benefits. And then a very important aspect of this is the avoided investment and the return on equity that would be associated with that for each of those categories. And then if you look at the next tab and then the following tab, so the next tab is costs, and it would have a kind of a separate tab provided by measure that would sum up to have this kind of cost summary tab. The following tab is the benefits tab that kind of coincides with that. And so the thought process was provide us with this detail based on, so that we can start looking at what are the programs that are going to be, that are going to drive the most energy savings in each year, and which years are those savings happening, and which measures or which mix of measures in those programs can drive demand savings, and in which seasons does that occur, and how long could that occur? And that last tab was broken down by benefits. That'd be looking at the capacity results. Obviously, we'd also have to look at the actual locational marginal prices of energy kind of as you went forward, but there are projections for that as well. And so I think if you used reasonable estimates of that, that can give you kind of a more transparent look at what those projected benefits might be, especially when you're combining that with a more transparent look at what that avoided return on equity of an avoided plant would be, and identifying the years that occurs in. And then that would provide us with the ability to kind of go through and look at, okay, I don't know what the exact number is, right? If there are 30 programs, okay, there are these measures that are located within a single program that really drive the result that's needed to avoid that investment. Those are the ones to focus on. Those are the ones that are going to be, that have the greatest potential to drive a ratepayer benefit. And maybe there's some other ones that are not very effective in doing so, but they're driving costs. That's really what's needed to kind of look at where are you getting the best bang for your buck. I know there was discussion about looking at the TRC. I'd caution against that, especially with the concerns that we've raised with all of the inputs into those TRC calculations. The importance is, when does the savings occur, which year and which season, and what are the costs that are to be expected. Those costs are going to be very, the costs in total are going to be fairly certain, and the benefits are going to be uncertain, and that uncertainty drives up when you provide a great deal of flexibility, and that's where we're concerned. So I do think that identifying those best performing programs and maybe limiting those programs to measures that make sense for the end goal that you're trying to achieve is of utmost importance. But I think what we have with what the company's proposed is an inability to kind of pinpoint that detail. And even if you could, the underlying assumptions that led to that conclusion are flawed.
All right, Mr. Lubert, thank you very much. I don't think I have any further questions. Any recross based on bench questions, public counsel?
Yes, just very briefly, Judge. Good afternoon, Mr. Lubert.
Good afternoon.
You mentioned in your discussions, I believe with Commissioner Mitchell, Dr. Mark's recommendation on the residential demand response program. Do you remember that?
I do.
You would agree with me that as part of Dr. Mark's recommendations, he encouraged a bring your own thermostat approach. Would you agree with that?
It's been a while since I've read his testimony. It wouldn't surprise me if he did mention that, but I can't confirm it without kind of looking through it again.
Okay. Would staff have any objection to allowing a customer to bring their own thermostat to participate in the residential demand response program?
My answer is going to be slightly caveated, but it's with good reason. I think what you have to look at is what the cost of incentivizing that bring your own thermostat customer would be compared to the benefits that you can achieve through potential reduction in the PRA, and recognition that you actually need to have that reduction occur in those peak hours. And so it's really important for the company to then kind of to implement the program in a way that actually achieves that end goal. But I think that is an area that it lends itself to being a relatively low cost as far as what the incentives would be. Now, I don't know what the administration costs would be, but I do think that that's an area that has the potential to kind of lend itself to driving benefits that could outweigh costs.
Thank you, Mr. Lubert. Thank you, Judge.
Ms. Van Gerben, thank you. Any cross from Renew Missouri?
No, thank you very much, Judge.
Thank you. Cross from NRDC?
No, thank you, Judge.
Ameren, Missouri?
I don't have any substantive questions, but I do have to ask, Mr. Lubert, it looked like that you were reading from something that was in your lap when you were responding to either OPC or the bench questions. Is that accurate, or
No,
is there anything up there in your lap?
no, my tie.
Okay. Phone?
My phone's in my pocket.
Oh, okay. Apologies. No questions, Judge.
Thank you. Any redirect from staff?
Yes, Judge. Well, I guess just to follow up on those Ameren questions, could that have been the schedule you were walking us all through?
I don't think that I had it on my lap. I don't really know where. I was thinking as I was speaking, so maybe I looked down a couple times, but no, I wasn't reading anything.
Thank you, Mr. Lubert. And just to make sure we have all of our acronyms defined in the record, what is LMP?
Locational marginal price.
I guess what is that?
Yeah. The locational marginal price is the cost of energy for Ameren. It would be through MISO, and when I refer to that, especially as it relates to an energy reduction for customers, it would be looking at the LMP, specifically at the Ameren load node. There are different nodes for all of Ameren's generators, and they have slightly different locational marginal prices than the settled load node.
And then when it came to schedule BJF-S1, you said that staff sent this to Ameren, Missouri?
We did. We sent this, it was after the initial application, but at least a couple months, if not several months before their amended application. Their response to Mr. Fortson is included in his rebuttal testimony, but essentially kind of what the response boiled down to is that they didn't want to get into that level of granularity within the workshops that we were going to have. They wanted to kind of keep things at a high level and talk to other stakeholders. And that's, like I said, it's detailed probably more thoroughly in his testimony. But that was the context there.
Thank you, Mr. Lubert. One moment. Thank you, Mr. Lubert. No further questions this time, Judge.
Mr. Pringle, thank you. Mr. Lubert, thank you very much.
Thank you.
This looks to be a good time to take hopefully a brief break before we get to Dr. Mark. And then I think we also have maybe some live testimony to take up after Dr. Mark. Is that correct?
That's correct.
And I believe that would conclude the hearing if we can get that wrapped up today, hopefully. So I'm showing it's just a little bit after 3:20. We take a break till about 3:35 and then resume with Dr. Mark. Anything from council before we take a break?
Yeah, Judge, before we go off the record, I just want to confirm, maybe I missed marking it down, but staff exhibits 200, 201, and 202, that's the direct testimony of Justin Tevy, the rebuttal testimony of Justin Tevy, and the surrebuttal testimony of Justin Tevy. I just want to make sure that that's been entered on the record.
It was my memory that we did, but I don't see it in my notes, which may not be completely accurate, but no harm in offering it and admitting it twice rather than not at all. So
That would be my preference, Judge.
Exhibits 200, 201, and 202, which would be direct rebuttal and surrebuttal of Justin Tevy.
That is correct.
All right. Any objections to those exhibits? Hearing none, exhibits 200, 201, and 202 are admitted into evidence.
Thank you, Judge.
Thank you. Anything further before we take another break? All right, we will be off the record until 3:35. Thank you. We're off the record. All right, good afternoon. We are back on the record. I believe we have Dr. Mark to take on the stand for cross, and then we'll have another, I guess, live witness. And then, if I understand correctly, that will be the end of the evidence. Is that correct? All right. And Dr. Mark, thank you. You're already on the stand. You are already under oath. Anything, Ms. Van Gerpen, before he takes cross-examination?
The only thing, Judge, is that this will be Dr. Mark's last time on the stand. So at this time, I would move, I believe his testimony has already been marked as 303 for his direct, 304 for his rebuttal, and 305 and 305 highly confidential for his surrebuttal. But we would move to admit each of those.
All right, any objections? Hearing none, exhibits 303, 304, 305, and 305HC are admitted into evidence. Anything further before he stands cross? Sorry, Ms. Van Gerpen, is he ready to take cross?
Sorry.
That's all right.
Yes, we
All right.
tender him for cross. Sorry.
All right, thank you, Quad. All right. Any cross-examination from staff?
Yes, Judge, thank you. Good afternoon, Dr. Mark.
Good afternoon.
So I'm going to ask you a few questions about the TRC. Does the TRC consider program costs?
It considers overhead administrative costs and the incremental cost associated.
And does the TRC?
I'm going to object based on foundation. Are you talking, could you lay a foundation for that? We have the company's TRC, we have TRC rules that we've been referring to all day. And so if you could just please lay a foundation.
On cross?
Yes. What TRC are you referring to? The TRC the company prepared? The TRC rules under the commission? I don't have a frame of reference to where in you haven't told me where in Mr. Mark's testimony. I'm just trying to figure, I'm trying to follow along.
Yeah, this is the company's TRC with the, yeah, this is the company's TRC.
Those are the costs.
Well, then I'm going to object again for asked and answered. Mr. Brueggemann was on the stand and already provided testimony about the company's TRC.
Mr. Pringle?
Mr. Brueggemann provided his answers. Now I'm asking those questions of Dr. Mark.
But Dr. Mark didn't make those calculations. Mr. Brueggemann did.
Yeah, I'm going to overrule.
Thank you, Judge. So, Dr. Mark, I think the next thing I was asking was, does the TRC consider incentive costs?
No.
Does the TRC consider TD cost?
No.
Does the TRC consider EO cost?
It depends. It would be the answer. So we're throwing around the TRC and the calculations in a number of different ways. My understanding is that Mr. Wills at one point calculated, he modified his testimony to include an earnings opportunity element within the TRC to provide that. And the commission rules require that in the IRP process. I will say that the IRP numbers are different than what's in this application, and I have not checked Mr. Will's work papers surrounding the earnings opportunity associated with that. And what gives me pause about that is we've had some issues over whether or not we're talking about the base earnings opportunity versus the additional incentives associated with the earnings opportunity. I would also just stress that when we're talking about the TRC, Mr. Brueggemann talked about a pre and a post TRC, and that's true, but we also, it's a matter of scale when we talk about the TRC, so, or any cost-effective test, really. So each measure has a cost-effective test, each program has a cost-effective test, the portfolio as a whole has a cost-effective test, And the underlying assumptions that support that are moments in time. So, when we're talking about, what is the difference between the baseline SEER in an HVAC versus another more Energy Star efficient HVAC, we are generalizing across the state with a number. When the reality of it is that those numbers vary. The cost of an HVAC varies considerably in Jefferson City versus the city of St. Louis versus Cape Girardeau, whether or not there is enough contractors, available within a given area where there's market competition. If one entity effectively owns all of the contract implementation of HVAC, that's going to skew the cost associated with products. These are the challenges that we've had with making programs cost effective and bringing down those overall payments. So I would have serious concerns about using any of the cost-effective tests as like the North Star for approving programs one way or the other at this point.
Thank you, Dr. Mark. One moment, Judge. Thank you, Dr. Mark. No further questions this time, Judge.
Mr. Pringle, thank you. Any cross from Renew Missouri?
No, thank you, Judge.
Thank you. Cross from NRDC?
No, thank you, Judge.
Thank you. Any cross from Ameren, Missouri?
No, thank you, Your Honor.
Any bench questions? I think I will have a few, and Dr. Mark, these are kind of along the same lines that I asked Mr. Lubert and Mr. Wills. I mean, could any of these programs be offered at a lower cost if the cycle length increased to 5 years or any other time for that matter?
You might be able to shave some cost off of having an assurance with a third-party implementer for more than 3 years than you otherwise would, say for like 5 years. There might be some savings associated with that. I say might because, as Mr. Liebert talked about, you're hitting diminishing returns each year that these programs move forward. Extending it 5 years, our pushback about any large extension of a portfolio is, again, there's so much uncertainty moving forward that if the commission grants a program for 5 years, 6 years, 10 years, for example, then you are locking yourself in a path-dependent position where we are stuck with that. A good example was Cycle 3. In MEEIA Cycle 3, parties came together and came to an agreement with Ameren, Missouri, and stakeholders. We stipulated to a path forward. We were not fortunate enough to do that on the Evergy side. That case went to hearing, and the commission approved a plan that was very different than what was approved through the unanimous stipulation with stakeholders in the Ameren case. And the results of that, I think, is reflected in program performance if you look at how it's played out. So, is there a path forward of making costs cheaper by extending it? I think the way forward is what I articulated, which is let's have a bridge program for a couple years that's light, that effectively can utilize, to the extent possible where it makes sense with IRA funds. But ultimately, you're moving towards a statewide program because the programs have to evolve. I mean, that's where you're going to get your cost savings. That's where you're going to get your economies of scale. Absent that, I struggle to see how these programs are going to be cost-effective each additional year moving forward.
Can you think of any other changes that could be made to decrease the administrative or program costs?
I mean, again, it would be a statewide program, would minimize a lot of the overhead costs and administrative costs that we're talking about. I've got thoughts on pays. I know that that has been brought up a couple times in its low TRC score. Context is really important for why that program is singularly unique, and how that may or may not contradict with a lot of our recommendations, because at face value, you look at a program like that from a TRC perspective, and it's very low. However, my testimony supports further, support of the PACE program. I would, point the commission to my recommendations in terms of bulk buying and the Fast Pass program, and basically the lessons learned. Again, we don't have confidence in the TRC ratios. If the commission moved forward with supporting programs that were within the application that are cost effective outside of the demand response program, my fear is that you're going to run into exactly what the commission's auditor said, which is that it's a 90-10 split, effectively, that the IRA funds are moving about 90% of, or responsible for about 90% of the adoption, and that Ameren would only be responsible for 10%. If you play that out, then I don't see how you can, with a straight face, support the programs. That's just, these things are naturally occurring, and given the overwhelming amount of cost that we're spending on overhead, the earnings opportunity, everything that's associated with that comes into question. And if I think if we keep things as what's being proposed, I think it's a very safe assumption that we will have a contentious EM&V.
All right, Dr. Mark, thank you. I believe those are all my questions. Let me see if we have any recross based on bench questions. Any from staff?
No questions, Judge. Thank you.
Thank you. Any from Renew Missouri?
None, Judge. Thank you.
NRDC?
No, thank you.
Ameren, Missouri?
No, thank you, Your Honor.
Any redirect?
Yes, just briefly, Judge. Good afternoon, Dr. Mark.
Good afternoon.
You, in your discussions with the judge, just mentioned the PACE program, and you mentioned that context is important when it comes to PACE. Can you explain what you meant by that statement?
So PACE is an on-tariff financing program. It's singularly unique. We came across the program because it was successful in dirt-poor co-ops, effectively. Programs, a utility like that, it's very difficult to promote energy efficiency for a variety of reasons. The PACE program worked in that context. We started exploring that sometime in the middle of cycle 2 and had discussions around rolling out a PACE program for Ameren, Missouri, and it was ultimately an agreed to part of cycle 3. And the rationale behind it was a larger looming question we had within the context of MEEIA, which is, what do we do now that the light bulbs are done? And the only answer is we've got to figure out how to capture more demand savings, more deep savings, and that's effectively comes down to HVACs. So HVACs were the PACE. The challenge with HVACs versus light bulbs should be somewhat obvious. There's no middleman, effectively, that's required to go ahead and change out a light bulb, jokes aside. The HVAC is much more difficult, and it's a huge capital investment for a lot of people. Most people don't have $10,000+ of disposable income that they can just go ahead and throw at an air conditioner and say, hey, my air conditioner's not dead yet, but this one's an Energy Star, and it might save me a few bucks over the life of it. In fact, we had Jigger Shaw, who is the USDOE's director for their loan program, the Energy Loan Program. It's billions and billions of dollars. Was a keynote speaker for Missouri, one of our Missouri state-wide energy efficiency programs. And Mr. Shaw said, and I've been able to verify this, that effectively 85% of all HVACs replacement takes place upon failure. And again, that makes intuitive sense to me. Most people don't think about their HVAC until it's not working. And at that point, they're largely at the mercy of whatever contractor is there and how hot it is. As a result, it makes, from a MEEIA perspective, extremely difficult to go ahead and move energy efficient products outside of that small window. So PAYS was our answer to that. Our PAYS was our answer to go ahead and do financing, but I say context was important because a number of things happened. So as soon as we rolled out PAYS, what happened? Well, we hit COVID-19. We had a year of programs that just stalled out because nobody could get in and do the audits of homes. Shortly thereafter, PACE financing got a lot of attention. And the PACE was on the John Oliver show. And Missouri was centered around PACE and the problems that were associated with PACE. But PACE sounds an awful lot like PAYS. So we had a lot of customer confusion around that. And then I had my own experience with PAYS. So 2 years into the program, I decided, I was going to have my father participate in PAYS. So I got on the Ameren website and called up the number that was listed there. And the operator effectively on the other side had no idea what I was talking about. So the program, was on the utilities website for 2 years with a number that didn't actually correspond to setting up times with PAYS. All that was brought to attention, and things moved, but we had issues effectively in terms of scaling it up, and ultimately the audits that were involved. So PAYS works like this. You contact the company, say that you're interested in having an audit, an energy audit. They have a below-door test that actually takes place on the premise, and you look at what it's incumbent upon those PAYS implementers then to find out what's the most cost-effective way for savings to materialize for you. So instead of trying to upsell you with a measure or saying that, well, the HVAC by itself is going to increase all of your worries, the below-door test actually looks at the whole home, where leakage is taking place, how that ductwork works. All of that results in more cost-effective savings, in theory, moving forward. In practice, what we got was a lot of what I would characterize as sort of 3 levels of customers. The first type of customer is very similar to what my sister-in-law is, extremely energy efficient. She came in for Christmas break and was telling me about the energy efficient windows that she had. And I can't stop thinking there's like, well, you're hitting diminishing returns by adding on Energy Star everything. The window savings that you would get are very minimal because everything else is sealed tight. Just a regular window would work. Well, PAYS helps eliminate that and minimize that. What we got was a lot of people that wanted to do this audit that were already really efficient. There were no additional savings to be made from it. And then we had the other extreme. We had people that just had, for a lack of a better word, I'll say toxic homes. They had, asbestos tape, set up. They had stuff where effectively if we did a blow-door test, we might disrupt the continuity or the integrity of the house and open up to all sorts of legacy toxic materials that could cause harm. So we can't do the audit. Well, each one of those has cost. We had to send out an implementer to go look at that stuff. And then you've got that third category, which is everybody else. So the home is still functional, but it's not efficient. Well, that's a matter of marketing and advertising that just really hasn't happened to date. And then you run into the problem that most people, again, it's a trust factor. And quite honestly, if there's a degree of skepticism that you get from, whether the utility will materialize in actual savings or not, again, another reason to promote a statewide program that is divorced from the utility. I could go on. I mean, like the list of the litany of things that plague this program is long. And I agree 100%. The TRC values are awful. The problem with it is if you do away with this program, if you do away with having an on-tariff financing program with the consumer protections in place, because that's the real critical key. That's why PACE had as many problems as it did, is because implementers were going in and making promises that they couldn't support. The liens on the house element, presented an additional hurdle for specific. Let me be real clear. I think PACE can work. Absolutely. It's just you had some bad actors involved in this. Well, it was very clear to us that our office didn't want to have any association with bad actors implementing a program that we supported. That's why we had the consumer protections in place. What has driven the challenge behind this is that the measures themselves have increased so much in cost. Part of that's due to inflation. Part of that's due to supply chain constraints following COVID-19. But a lot of that has to do with consolidation of this industry. So what you had was, if you look at the number of like mom and pop HVAC companies out there, they're effectively getting gobbled up by larger entities. And as you have less market competition, it's driving the cost up, that's available. All of this has an impact, again, which could be minimized if we went to a statewide program. You take away PAYS, you're taking away the opportunity to try to reach the customers that we want to reach. Effectively, the vast majority of Ameren, Missouri customers that don't have huge capital investments just sitting in their wallet that they can throw at something. And we are largely dependent on just doing a rebate program and then following up and seeing whether or not that influence was directed because of the IRA funds or not. And I think it's very clear if you go down that path, you're going to get a very low net to gross ratio. That's not going to justify all of the work and all of the time that's required of proper regulatory oversight, and from the company's perspective of implementing this in a meaningful manner. So there's a pull-push on everything that you do. That is the problem with me, is that it's all interdependent with each other. So if what I'm saying comes across as sometimes circular logic, it's because it is. It is a challenge. And there are, again, my testimony articulates a way forward that I hope the commission strongly considers.
And Dr. Mark, just to follow up on your discussion with PAYS, you have made a recommendation to tweak PAYS a bit for this case. Is that correct?
That's correct.
And would that change, would that help to make the program work a little bit better?
Oh, gosh, yes. I mean, I said before, 85% of HVACs are taking place upon replacement upon failure. My recommendation is to implement something called the Fast Track program, which would effectively try to get those customers at the point of failure to introduce that energy efficient option. And that would be tied back to, properly citing it and the audit associated with that. The other avenue there, quite frankly, is bulk buying. There's a process there. I mean, if you want to make the programs work, you got to figure out a way to make these measures cheaper. We have economies of scale with bidding powers. My God, we do that in all sorts of settings. There's a real value in that. There's a reason why Ameren is able to go ahead and attract capital cheaper than a smaller investor-owned utility like a Liberty Utilities. It's got 1/10 of the customers. I mean, there's a variety of reasons for that, but my point being is that there's value in economies of scale. Absent that, it's frustrating from my perspective, because if we do want to move forward with valuing demand side management, there are either market alternatives that we can lean on, like ARCs. There are federal initiatives that are out there. Or there's a path forward that is more consolidated, that can lean on economies of scale and use that bidding power to go ahead and bring the overall cost down. But it probably will require legislative changes that, again, if the commission is interested in that something, the direction we could get from the commission sooner rather than later will certainly help.
Thank you, Dr. Mark. I want to switch gears just a bit. You've mentioned several times a bridge program. Could you explain what you mean by the bridge program?
So I'm going to make an analogy for you. You think of it, just we'll use medical terms here, and we'll just say like we've got somebody that isn't particularly healthy. The bridge program is a 2-year program that's effectively a lighter version of what the company has offered. It's trimmed of the fat without betraying the long-term objective of trying to make energy efficiency work for everyone, including non-participants. The analogy that I'd give is, think of 3 different interventions that you could use to go ahead and make your body feel better if it's getting worse. And I would say demand response, the business demand response, the residential demand response is an immediate reaction. And that's the equivalent of like taking Advil or Tylenol to go ahead and deal with a headache. It deals with that peak issue for a moment, but long term, you just can't keep using that. You probably need some lifestyle changes. And that's where energy efficiency comes in. So you could have those lifestyle changes, and they could be born, either behaviorally or, through actual measures that you could put in place. That's a long-term projection. That's a long-term approach to things. And then you have time of use rates. We could just price things correctly, and I would characterize that as more of a diet, where we're looking at caloric intake. Just pricing energy in line with the actual cost of service and its impact on rates has shown to be extremely cost effective. TRCs of 10 to 1. If I'm valuing it on an equivalent basis, I think you have to look at all 3 of those options moving forward to address that. Unfortunately, the way things are structured right now is preventing us from doing that. I think, having an open and honest dialogue about what demand side management looks like moving forward starts with exploring the idea of a statewide program and taking it from there.
So just so the record's clear, would you recommend that bridge program if we were not moving towards a statewide program?
No. I mean, what's the point? Just lowering the budget of our overall program on just cost-effective measures. I mean, yeah, that's I guess better than keeping it as programs that are clearly not cost-effective or bad. But as I talked about with the PACE program, I think that TRC is misleading in terms of its potential. And we've got market potential studies that have done on PACE that have shown that the potential really is there, if it's done correctly. Now, just lowering the budget and then being subject to the whims of what takes place with the IRA just decreases your ability to accurately say that we're actually deferring anything meaningful. So again, it's the appetite of the commission, I guess is what I would say. If you want to pursue this, I think it requires a good hard look of what we're doing and how we can modify it. If not, if the option on the table is just what the application is, then I can't in good consciousness support that.
Thank you, Dr. Mark. Nothing further, Judge.
Thank you. I think I'm going to have just a couple of follow-up questions. Dr. Mark, are you aware of any on-bill financing programs across the country that have been more successful than PAYS?
I think PAYS has been successful in other places, and I think there's no reason why PAYS can't be successful here. I've articulated some of the challenges that have arisen out of PAYS, but those, again, we modify and we learn. As far as other on-bill financing, which is different than on-tariff financing, that's an important distinction. I think PACE, depending on who you ask, has a mixed track record, and that also extends beyond energy efficiency upgrades. That's a lot of that has to deal with rooftop solar. The program where I have seen some success has been Spire's financing program with their energy efficiency programs. Has had limited, your Spire's energy efficiency programs are a rounding error relative to like what we're talking about with Ameren. I don't think that there is a particularly good model right now. And I have looked. I mean, I can't find another more consumer-friendly model than PAYS. The low interest rate, the 80% rule that guarantees savings, you know, or that is designed to guarantee savings. I should air quote that. Those consumer protections are critically important. And my concern is if the commission moves forward with a different financing model and it doesn't work, we don't have those consumer protections, look no further than that John Oliver show where we had, you know, an hour and a half on cable TV highlighting the challenges of Missouri. And I get that it's biased and it's talking about a moment in time, but that's all it takes to color the perception a lot of times.
Instead of an on-bill financing program, might some sort of on-bill repayment program be more cost-effective? A program wherein the utility is just collecting the loan repayment and not providing the capital?
I mean, I struggle with how that's different than what we're offering. You know, the utility's able to earn a little bit, you know, in terms of the interest that's associated with that, but we've arguably kept that artificially low to reflect our ability to move these products. I'm not opposed to different ideas, and I think that's worth having an active dialogue about. I would point out that we have now programs of PAYS across the state and are modifying it as we speak. If the differences between, you know, what's being applied in this application versus, you know, we're not in support of the application, even with the PAYS program. But if you move forward with something, I strongly recommend you don't throw out PAYS. You got to figure out a way to address the residential sector. And the vast majority of customers that just don't have the capital for these measures.
All right. Thank you, Dr. Mark. I think those are all the questions I have. Any recross based on those additional bench questions from staff?
No questions, Judge. Thank you.
Thank you. Renew Missouri,
No questions.
NRDC,
No, thank you.
Ameren, Missouri.
None, Your Honor, thank you.
Any redirect?
Just very briefly, Your Honor. Dr. Mark, just to clarify, you mentioned Spire's efficiency programs, and you mentioned that those were a rounding error. Could you explain why that is?
Spire doesn't have a MEEIA. Spire's energy efficiency programs, Spire doesn't get lost revenue adjusted for their energy efficiency programs. Spire doesn't get an earnings opportunity associated with their programs. Spire does have, for the size and the dollar amount that Spire has, I think it's a well-run program. But the obstacles with the natural gas company versus the electric company should be pretty obvious, in that the whole premise behind MEEIA is that we're avoiding future costs, future build out of generation, future transmission and distribution. We're not avoiding a future gas plant, right? There's just different economics associated with that. The Spire programs, as a result, you know, we've contested the Spire programs in rate cases before, but ultimately we have settled out with parties and have made sense, I think, with programs that make sense given the context of what Spire's attempting to do. And again, to their credit, I think they've been very receptive to our feedback and have done well.
Thank you. That's all I have. Nothing further. Thank you.
Ms. Van Gerpen, thank you. Dr. Mark, thank you very much. You may step down. And I believe that's the end of the witnesses we have on our list of witnesses, but we have one witness that's going to provide live testimony. Is that correct?
That's correct. Ameren, Missouri would call Timothy V.
All right. Mr. V, if you'll come forward, and you've already been sworn.
Sorry, I always mispronounce his name. Mr. Vi. And he was sworn, he's testified before, so I don't know if he needs to be resworn.
No, you're still under oath, so you may have a seat and Ms. Hernandez, when you're ready.
Can you please explain what the 11-step process is?
Yes, so the 11-step process was implemented as part of our MEEIA 3 programs to make things more efficient when we have to make changes. As I mentioned earlier, through that process, it's a collaboration process with staff and OPC and other stakeholders as well. So we wouldn't have to make tariff changes or whatnot. So it increases flexibility and not have to be bogged down by a more cumbersome process.
Okay, and what do you do when you're proposing like a process or an incentive amount change through the 11-step process?
11-step process, it obviously, it includes 11 steps, therefore the name of it, but I guess to summarize, we work with our implementation contractors and they may offer up an incentive increase to help influence or gain additional participation. If that means we look at that, we send that information, we share that with our evaluators to get their opinion. So we look internally with our portfolio and the cost of our portfolio to get that. We look at what changes would have to be made on our website. So it's a long list of processes that we go through, and eventually what we do, we will present that to stakeholders. So we would present that out, and we normally follow up with calls with the stakeholders and see if they're on board. As I mentioned, through MEEIA 3 cycle, we've had 28 such 11-step processes we went through, all of which we've came with agreement with stakeholders and moved forward with those. We do not have any instances where there was a disagreement with stakeholders and we still went through with the process. So it's a collaborative process, but as I said before, it minimizes the resources needed to make those corrections. If we, outside of that, if you think back to before that process for MEEIA 2, if we make an incentive change, we would have had to go through a change that would update the whole process. It would have to be filed, and then that file would take time. It would have to go through the process of getting commission approval and whatnot. So if you think about it, during this MEEIA cycle, probably every month and a half to 2 months, you would have had to been ruling on something like an incentive change, and that's why we have the incentive range that we've identified in our plan in Appendix D.
And do you have a copy of Mr. Kiesling's changed rebuttal testimony?
No, I do not.
May I provide him a copy, Judge?
You may.
Thank you.
And if you could look at page 7, in particular, the lines 14 through 17 of the change testimony.
Okay.
And it talks, well, it reads, the 11-step process is currently constructed as a notification process that defers to the company's discretion for changes. Stakeholders can provide feedback, but the company isn't obligated to incorporate any stakeholder feedback. Do you agree with Mr. Kiesling's statement and his change testimony?
I'm not saying what you're reading, so I'm not sure.
Oh,
He doesn't, that's the testimony, is that you took the wrong.
I think what I have is the actual testimony, not.
Yeah, those are the changes, they didn't file.
oh, you have his, I'm sorry.
No, they only filed the PDF with the changes.
old version of this, not the corrections. You can do that.
Oh, I can keep them.
Those are-
Okay.
I apologize. So on that document, it talks about a change to Mr. Kiesling's testimony at page 7, line 14 through 17.
Correct.
And that's the change I just read. If you need to take a moment to look at that,
Okay.
just let me know when you're ready.
I'm ready.
Okay. My question is, do you agree with the statement that Mr. Kiesling is making in his changed rebuttal testimony?
No, I do not agree with that. As I stated, we've had 28 such 11-step processes during MEEIA 3, and we've always came up with agreement with stakeholders. Many of those, them agreeing to what we originally stated in the stakeholders, but we do keep consideration of their feedback, and if they have questions, we may go back and get additional detail to help support or to answer any questions that they may have.
Do you involve staff and OPC in the 11-step process?
Yes, I do. Or we do.
And have you ever moved forward on an 11-step process without an agreement from staff and OPC?
No, we have not.
Could you please explain some of the 11-step process changes that have occurred during the MEEIA Cycle 3 through 2023?
Yes, we've had various changes. We had, give me an idea, we had a change with business social services program where we wasn't getting uptake in HVAC for that program. So we made an incentive change. We requested an incentive change through the 11-step process where we increased the incentive for that to gain additional participation by customers to participate in the program and make those upgrades to the program. I also would like to point out, I mentioned earlier that we had a similar process, 11-step change within our multifamily income eligible program where we lowered the incentive because we thought the incentive was too rich. So they give me that just gives you a context that some of the incentive changes could be high, some could be low, lowered to meet the participation level for the customer participation.
And do you make those changes to maintain a level of continuity in the programs so customers can participate?
Can you repeat that, please?
Do you make those changes so that there can be a continuation of the program and customer participation in those programs?
Yes, we do.
If the commission adopts staff's recommendation and rejects the 11-step process and requires the incentive amount for each measure available through each program to be in a tariff, in your opinion, what would Ameren, Missouri need to do to change the incentive amount?
We would have to make a tariff filing for each of those changes. As I mentioned, each one of the 11 steps we did that I mentioned in the 28 was not all incentive changes, but the majority of them was incentive change. So we would actually have to file that new tariff change and get that approved.
And currently, how long does an 11-step process take to complete?
It normally takes less than from the time we initiate and provide it to staff until we would make the change is normally roughly 10 days, I think.
And do you have an opinion on how long it would take to change an incentive amount if you needed to file a tariff change each time?
it probably would take over 2 months.
And during that 2 months, what would happen to that program while Ameren, Missouri was waiting on a decision on the tariff change from the commission?
The program would stay stagnant at the incentive levels. If the request for it was an incentive change, it would stay at the incentive levels that were on file.
And I believe earlier in the week, Commissioner Holzman had asked about things that could help increase participation. Is it your opinion that the 11-step process is a tool to help increase participation in programs?
Yes, I think it is a tool to help us manage participation. I think it helps manage participation and manage the budget in both ways.
Nothing further. I tender the witness for cross on this issue.
Mr. Hernandez, thank you. Any cross-examination? Renew Missouri. Hearing none. Any cross from NRDC?
No, thank you, Judge.
Thank you. Cross from staff?
Judge, at this time, staff would request a 10-minute break to gather their thoughts on this new information before proceeding with cross.
Well, I'm just going to put it on the record, Judge. This was a last-minute change of staff that was filed last Friday before the hearing started, and we had little time to prepare and didn't even have time and an opportunity to go through what the rules require in terms of filing written testimony on the issue. So I don't know why another break is necessary at this point.
May I respond?
Sure.
Judge, the filed testimony, even though it took place on Friday, allowed for over 72 hours of consideration. We're asking for 10 minutes.
All right, we will take a 10-minute break. We'll come back on the record at 4:35. Thank you. We're off the record. Brian, are you ready? All right, good afternoon. We are back on the record. I believe we're ready for staff to cross-examine this witness. Are we ready to proceed?
Yes, thank you, Judge, for the break.
Thank you. Whenever you're ready.
I'd like to go through some more of Appendix J, which is the 11 steps. Are you familiar with Appendix J?
Yes.
So whenever you're going through the 11-step process, does changing incentives impact the total resource cost calculation, the TRC?
I would refer to Jeff Brueggemann's testimony that as long as the incentive does not go above the incremental cost, then the TRC would not be affected.
Because incentives aren't included in the TRC, right?
I would have to refer to Jeff Brueggemann's testimony on the definition of how it's modeled within the TRC.
Okay. Do you know where the high range of incentives included as a sensitivity analysis and included in Ameren, Missouri's testimony or work papers in this case?
Can you repeat that question, please?
Were the high range of incentives included as a sensitivity analysis and included in Ameren, Missouri's testimony or work papers in this case?
No, I think what was included is the incentives that are in the submittal tool that was filed as the best forecast of our implementation contractors to meet the savings and megawatt and energy goals that set forth for each individual program.
So does changing incentives impact program costs?
Change in incentives can impact program costs, but as I stated, some of those incentive changes are positive, some of those incentive changes are negative, or increase and decrease.
If Ameren's MEEIA 4 plan is approved without modification, will the measures available under each program change from what's currently in place?
I would like to say that it wouldn't change, but it could be a new measure if it became cost effective, or through the design of the program, if it became available, then we would look at it. I give example, we did the income eligible programs as we move multifamily income eligible programs. First time when we did those programs, we was just changing out low cost measures inside the home. Then working with that program, we looked to increase the savings of that, and which included a tune-up. And then now to where we're at now, we're doing a comprehensive type program that includes HVAC, a partnership with Spire to include furnace replacement. We include air sealing, insulation. So it's a whole gamut for that comprehensive, but also from the results of that, from our past evaluation, it showed that we save customers roughly 30% average savings per customer in that program, which equates to almost eliminating three bills annually.
Okay, so if Ameren's MEEIA 4 plan is approved without modification, it is entirely possible that the measures available under each program would change or could change?
Most of the programs, the measures would not change, but it could be. Another thing that potentially would change, if you think about since the inception of our program, if there's a federal standard, then that could have measures that may be incentive that would not be incentive. But I do not foresee any of those federal standards in the near future.
But there's no prohibition that the measures available under each program stay the same. I mean, there's no prohibition from it changing, correct?
If the measures were to change, then we would have to make a modified change, and we would go through the 11-step process to add additional measure. And if that measure is not in the TRM, then we would make it be modified and updated as such.
I think you spoke to this earlier, but can you clarify it for me? What's the implementation timeline as envisioned by Ameren's 11-step process?
I think from the time that we look at, I think it's somewhere between 7 and 10 days from when we actually provide the data to stakeholders for review.
And how many days do stakeholders have to evaluate and respond?
I would have to look at to be exact, but I think it's 5 days.
Is Ameren required to incorporate the feedback from other stakeholders regarding a change in accordance with your proposed 11-step process?
The 11-step stakeholder process was a collaboration between staff and OPC to make things more efficient going forward. So therefore, working that process, taking their input is part of that process to make things more efficient and to move things forward.
I want to clarify my question to you. I appreciate your answer, but it didn't answer the exact question that I asked. The question is Ameren required to incorporate feedback from other stakeholders regarding changes in accordance with your proposed 11-step process?
The process was designed for us to take their feedback and have a discussion to move things forward.
Are you required to take their feedback and implement it?
I'm not, as far as legally, I'm not sure if we are required or not, but as part of the process, it was a collaborative process. Part of that collaborative process was for us to provide our recommendation for the 11th step, and if they are not in agreement or need additional insight, then we'll provide that and we would discuss that before moving forward.
Okay, let me ask you a follow-up to that. Do stakeholders have any form of recourse if the company does not incorporate suggestions or feedback? Is there an appeal process?
I'm not familiar with what the legal ramifications of that would be.
Is it your testimony today that you're not familiar with whether or not your 11-step process has an appeal?
As I mentioned, we've had 28 11-step processes that we applied, and we've always been in agreement with stakeholders. So we have not went against them. We have not moved forward without their agreement or acceptance of us moving forward with the change that we're requesting.
But there's no prohibition from Ameren doing that if they wanted to, right?
Objection asked and answered.
I'm going to overrule. I know it's been asked, but I don't think it's been answered.
I'm not aware of any recourse that could be by the company of such change.
Is there recourse for stakeholders if the company chose not to incorporate suggestions or feedback during the feedback period of 5 days in the 11-step process?
I'm not aware of any.
Thank you. I'd like to talk a little bit about your response to the estimated time frame for tariff change filings. So you estimated a 2-month time frame as opposed to the potentially 8 to 10 day implementation period that you've referenced in the 11-step process, right?
Correct.
Are you aware that tariff changes can and do occur on a shorter timeline than 60 days on a regular basis?
Yes, I think, from my knowledge, that it's a 30-day, potentially a 30-day ended process for parties to, reject or approve or provide comment, and then it takes time for the official ruling to be accepted. So what I've seen is it could take up to 2 months or longer.
So it could take up to 2 months, but it also couldn't, right?
I would have to ask, I'm not a person that files and gains approval for those, so I would have to ask my legal counsel on the process.
Understood.
That.
Are you aware of the ability for your counsel to request expedited treatment of tariff change filings?
Familiar with the process, yes.
How many 11-step incentive changes have been incentive increases? You said most, but then you've also referenced the low income that was a decrease a few times.
I think it varies. I can't be precise. Some of them would go up, and some changes would go up, and then it may be 11 step to bring it back down.
But the majority are increases?
I wouldn't say the majority, but I don't have each itemized 11 step in front of me to say which ones were increases and which ones are decreases. The ones I spoke to is I know I've been personally involved in, so that's how I can speak directly to those.
Have you not been personally involved in all 28 of the 11-step processes that have taken place over the last 5.5 years during cycle 3?
I'm in the notification chain of those, but those that I was speaking to is when I was implementing programs, it was changed that I requested and led those processes.
And the majority of those, as you testified earlier, were increases?
No, I said there was a mix of both, increases and decreases.
Okay. Can you give me a rough estimate of how many measures are included in the TRM? Just a rough estimate. Hundreds, over 1,000?
I'm going to object. That's beyond the scope of this limited issue of the 11-step process.
Ms. Johnson?
The TRM's been referenced multiple times, even in this limited scope. We've been talking about it all day and how much it's relied on for the calculations that come out of it to support the application, which includes the 11-step process.
All right, I will overrule.
I'm not aware of the number. That could probably be better addressed by Neil Gracer of our analytics team.
Have you looked at the TRM?
I'm familiar with the TRM, yes.
Can you give an estimate of how many tabs and calculations it includes? Is it more than 100?
I haven't went to it in that much detail to know how many tabs it is, but I know that it is in our filing, so if you want to reference the filing, it's easy, you can go through that and see how many are in there, but I don't have that in front of me or have those numbers in front of me.
Is it fair to say that it's hundreds of pages?
Potentially different volumes of that could be, yes.
Thank you. I'd like to go back over the 28 11-step processes that you referenced have taken place over the 5.5 years of cycle 3. Are you familiar with Ameren Exhibit number 116 that your council prepared at the request of the chair for which programs are currently active?
Again, I'm going to object. This is, again, going beyond the specific issue that he was called for direct based on the last-minute change of staff's rebuttal testimony, and it's just not relevant to the issue that we're discussing right now.
Ms. Johnson?
Judge, the 28 11-step process changes that have taken place across the 13 programs that are listed in the exhibit provided by Ameren's own counsel.
Right.
I think that's a
I'm sorry, go ahead.
I think that's a fact, not in evidence, and
All right, I'm going to overrule.
Mr. Vai, my question was if you were familiar with Ameren's Exhibit number 116 for the current programs that are active based on Ameren's application in Cycle 3 and the extensions.
I'm not familiar with the exhibit. I have not seen the exhibit.
Do you have an idea of how many programs are currently active from the Cycle 3 portfolio?
I'm familiar with the Cycle 3 programs that are active, that are currently active, yes.
So if I were to tell you that your own counsel provided a list of 13 active programs, would you agree?
I would have to see the document to see what that exact total is.
If it's all right, Judge, can I provide a copy of Ameren's own Exhibit 116 to the witness?
You may.
Mr. Vai, can you take a second to look over that and count the programs there?
Yes.
What's the total number of programs that your counsel provided to the chair that are currently active?
It shows 13 programs on this exhibit.
I want to make sure I understand that I want to make sure I'm right here. So if there are 13 active programs and there have been 28 11-step processes to change incentive amounts in those programs, that means that many of those 13 programs have had more than one 11-step process performed on them, right?
Yes, that could be, yes. Potentially.
Okay, and that's over the Cycle 3 and extension time period, which to date would be about 5.5 years, right?
Correct.
If I were to tell you that the incentive changes often take place in the fourth quarter, would that surprise you?
I would say it varies.
The reason for an incentive change that increases the incentive would be to drive participation, right?
Some of it is to drive participation, some is to keep up with the costs. As been mentioned earlier, there's been price increases with supply chain, whatnot. So, for instance, for our multifamily or multifamily income eligible program, the cost of HVAC systems increased. So we did a lot of costs increased during COVID. So some of those adjustments was to increase the cost to accommodate with that.
Does the 11-step process contemplate a requirement by Ameren to change tariffs if incentive amounts are included in the tariffs?
Can you repeat that?
Sure. If the incentive amounts were required to be in tariff sheets, does the 11-step process include a step that would contemplate the need for a tariff change already in the process? Is there a framework for it in the 11-step process already?
I think that you're talking about two different things. Updating a tariff and updating 11-step is two different processes.
I like to read step 10 to you and then ask you an associated question. Step 10 in Appendix J says, file updated plan appendices or tariff sheets, if applicable, in the current case number. So I'll ask again, does the 11-step process contemplate a framework for the need to file tariff sheet changes?
From what you read, if applicable, but because we have the incentive ranges that are filed, you do not have to file a tariff change based on incentive change, as long as it's within the incentive range.
Understood. So you don't have to file a tariff change now, but it is contemplated and there's a framework for it in the 11-step process based on what I read, correct?
Incentive changes is not the only thing that's utilized by the 11-step process. If something requires a change, then it would be. To give you an example, part of our business social services program, it contemplated we had 11-step that we provided to stakeholders that involved including municipalities and schools. I think it was schools above that had free lunches above 50% were free lunches. That constituted a change to the tariff. Therefore, there was a tariff change with that 11-step.
So there is a way to incorporate the need for a tariff change in the 11-step process.
If applicable.
Thank you. Just 1 second, Judge, please.
Certainly.
Staff has nothing further. Thank you.
Ms. Johnson, thank you. Cross from Public Counsel.
No, thank you, Judge.
Any bench questions? Hearing none. Any redirect?
Possibly, but I'd ask for the same courtesy to have a short break.
10 minutes?
Thank you.
All right, we will be back on the record at 5:08. All right, good afternoon. We are back on the record. I think we are back to redirect of this witness. Ms. Hernandez, when you're ready.
Thank you. Mr. V, does every 11-step change now have to go through a tariff filing change?
No.
And do you have, well, let me ask this. Has there ever been a time when stakeholders have asked for more time to review an 11-step change and Ameren, Missouri has denied that request for more time?
No.
Nothing further, thank you. I would, at this time, like to offer his testimony. The exhibit numbers. Let's see, Exhibit 107, that would be Mr. Vai's direct testimony. Exhibit 108, Mr. Vai's rebuttal testimony, and Exhibit 109, Sir rebuttal testimony.
All right, exhibits 107, 108, and 109 have been offered. Any objections? Hearing none, exhibits 107, 108, and 109 are admitted. Mr. V, thank you very much. You may step down.
Thank you.
I believe that is the end of the witnesses. Anything further from council?
Yes, Your Honor. We haven't moved for Ameren Exhibit 116, and I do so now. Everyone will recall we just had Mr. Vi go through that, and those were the programs requested by the chair earlier today.
Okay, exhibit 116 has been offered. Any objections? Hearing none, exhibit 116 is admitted.
And then, Your Honor, I think yesterday we made a request for the commission to take administrative notice of the program year 2023 evaluations filed in EO 2018-0211. Those two reports were, one was the EMMV audit of Ameren, Missouri, filed on June 11th, and the other was the program year 2023 evaluation report filed on June 10th, 2024.
Right. Any objections? Right. Hearing none, the commission will take judicial notice of that.
And then finally, Your Honor, yesterday we requested the commission to take judicial notice of EO 2024-0020. We've narrowed the scope to the initial filing made on September 9th, 2023, which includes the IRP chapters and appendices, and the corrected plan filing on April 2nd of 2024. Did I say Plan I?
I don't think you did, but
Yeah,
okay.
well, it's the corrected Plan I filing from April 2nd, 2024.
All right. Any objections?
Your Honor, this is Lindsay with OPC. We are objecting really on, I guess, several grounds. So first would just be kind of a due process concern. Those documents, the initial filing in particular, is, as I understand it, extremely voluminous. And that's not something that I'm familiar with or have had time to really delve into. So it would just be a concern that the entire document would be coming in and our witnesses really have not had a chance to respond to the substance of that document. So that's a concern that we have. And we would also be concerned with, on a hearsay ground, if the document was coming in to prove the truth of the matter asserted without being supported by a witness.
Your Honor, if I may.
You may.
OPC and other parties had a chance to respond to the comments of the IRP plan on March 8th. But as a more substantive matter, I just want to point out that the company bears the burden of proof in this case. And part of that burden and part of the commission rules require that the company analyze the impacts of the annual revenue requirements, and it goes on, but it's in accordance with Chapter 2260 over the 20-year plan horizon. We've had testimony all week long regarding the IRP and the company's load capability and the support for that. And furthermore, throughout this week and these documents, it's been alleged that the company hasn't provided enough information or lacks information or hasn't met the commission requirements. And again, the rules in MEEIA require that the plan be advised by the IRP, and so we simply asked to have this moved so we could have a more comprehensive record.
I'm going to overrule, and the commission will take judicial notice of the documents as requested by Ms. Moore.
Thank you, Your Honor.
You're welcome. Anything further from council?
Your Honor, I have two quick things. So on our very first day together, the commission had asked that my opening presentation be offered as an exhibit. How would the commission like me to get that to them?
You're certainly welcome to file that in EFS.
Okay.
And as a late filed exhibit, and then I can give time for parties to object if they wish, and then we'll go from there.
Okay. And again, just to make clear, while we're here on the record, and I can include this as well, that we would just offer that as a demonstrative.
Certainly.
And then the second thing, I believe I've done this previously in hearings. Could I just make sure that all of our exhibits have been admitted?
Certainly.
And I have here 301 through 305, and that's just the testimony of the OPC's witnesses.
If you'll give me a moment, I have found 303, 304, and 305 immediately. And I see 301 and 302, and they've all been admitted into evidence.
Great. Thank you, Judge.
You're welcome. Anything further from council?
Yes, Judge, staff would like to confirm on their exhibit numbers also. We believe that we have offered and have been admitted 23 exhibits up to number 223. Is that the same that you have?
If you will give me some time, because we jumped around, but I will verify.
Thank you.
I'm sorry, that was 201 through what number, please?
It should actually be 200 through 223, so a total of 24.
200 through 223, all right. Yes, I show all of those offered and admitted.
Thank you, Judge.
You're welcome.
So, Your Honor, if you could indulge me, do you also have Ameren exhibits 100 through 114? And then we did not tender 115, and then I believe you just admitted 116.
I will check if you'll give me just a moment.
Yes, thank you.
I'm sorry, that's 100 through 114.
14. And then the 116. So the 114 were the revised Appendix A through O. I think they were admitted yesterday.
I will keep checking. Up there it is, 114. So I have 100 through 114 and 116.
Great, thank you, Your Honor.
Yes, those have all been admitted.
Yep, we match.
Very good. Anything further from council? All right, thank you very much. We will look forward to reading your post-hearing briefs. Thank you. We are off the record.
Thank you, Judge.